think he's in live. It's in live now.
Okay,
Okay, yeah, we are ready.
ready?
Yes.
Good morning. I'd like to call the Code Enforcement Special Magistrate hearing to order for the town of Pembroke Park for Wednesday, May 18th, 2022. Council chambers, it is approximately 9 a.m. I will make a brief opening statement about the proceedings. Thank you all for being here today. Please turn off any cell phones. No weapons of any kind are permitted in chambers or in the facilities. Please, no outbursts or interruptions. The hearings are conducted for the purpose of giving the alleged violators the opportunity to contest the decision of code enforcement, which resulted in the issuance of the violation. The hearings are conducted in a quasi-judicial manner. I am the special magistrate assigned to hear the cases today. My responsibility is to act much like a judge in a court. I hear the evidence presented by code enforcement, and I hear contradictory arguments presented by the violators. Hearings are open to the public. All persons who testify have to be placed under oath. The hearings are not conducted in accordance with the formal rules of evidence and witnesses. Any relevant evidence can be admitted if I find it to be competent and reliable, regardless of the existence of a privilege. All documentary evidence must be submitted into the hearing file. Documentary evidence cannot be considered unless a copy is in the hearing file and submitted into the record. Each party has a right to call and examine witnesses, introduce exhibits, cross-examine, and to rebut evidence against him or her. The responsibility of the magistrate based on the evidence is limited to whether the alleged violation occurred. If so, whether the persons named can be held responsible for the violations. I can also modify the decision of the code enforcement officer as to the time for correction in the notice, even though the time is rebuttably presumed to have been reasonable. I have the authority to assess civil penalties, to issue orders having the force of law, command whatever steps are necessary to bring a violation into compliance, and to assess administrative costs. In order to make a finding upholding code enforcement officer's decision, I must find that there's substantial competent evidence that the named violator is responsible for the violation of the relevant section of the code as charged. If I affirm the decision of the code inspector, the order will specify the amount of the civil penalty, the administrative costs of the hearing, which are always a flat fee of $100 per case, the date by which the violation must be corrected or cured to prevent resumption of continuing violation penalties, of any. Any aggrieved party, including the town, can appeal the final order of the magistrate to the Circuit Court of Appeals. Such an appeal is not a new hearing, but is based on the evidence before the special magistrate. Appeal has to be filed within 30 calendar days of the order sought to be overturned. Please remember that if there's a finding of guilt, there's a standard administrative fee of $100. City representative will present their case first. The alleged violators will present their case thereafter. The evidence will be considered, and I will render a decision after all arguments are heard. Thank you. We're going to take the roll call. Okay. Present are myself, Special Magistrate Rafael Suarez-Rivas.
Chief Code Enforcement Officer Jocelyn Ramirez.
Code Enforcement Officer ERIK RICHWAGEN.
Code Clerk Mary Curry.
Assistive Administrative Nasli Cardona.
The agenda, are there any changes to this agenda?
Yes. On page 2, section 6.5, case 5517 has complied, so we're removing it.
Okay. Case number 6.5 is removed.
And case 6594 on the same page, 6.9, they've complied.
Okay. Case 6.9 complied and it's removed.
And that's it for me.
Mr. Magistrate, page 4, item 7.1 has been pulled. They have entered the amnesty. 7.2, case 6000 has complied.
Okay, so 7.1 is pulled, 7.2 is pulled,
Yes, sir.
removed.
7.4, case 6801 has complied.
Okay, they are removed.
Yes, sir. And 7.6, case 6819 has also complied and has been pulled.
That case, 7.6 is removed as well. Anything else?
No, sir. That concludes it for me.
Okay. Anybody who wants to testify has to be sworn in. Who wants to do the swearing in? Do you want me to do it, or do you want?
You, Mr.
Okay.
Mr. Magistrate.
Anybody who's going to testify, that includes code enforcement officers, you can't speak if you're not sworn in. Raise your right hand, affirm the testimony you will give is the truth and nothing but the truth, so help you God. I do.
I do.
Thank you. We can proceed.
Okay, first case on the agenda would be 6565.
6565.
And that's on page 6,
On page 6, actually.
section 9.4.
6, 9.4.
Okay.
Okay.
Chief Code Enforcement Officer Jocelyn Ramirez for the town of Pembroke Park. Property owner Han Hala LLC. Tenant All Ways Towing and Storage Inc. Site address 2550 South Park Road, Pembroke Park, Florida. A notice of formal hearing to abate fine was sent out by certified mail on May 4th, 2022, and posted to the property on May 6th, 2022. This matters here today to abate a fine of $750. It is the town's motion to reduce this fine by 15% of the per diem fine, which is $112.50.
This is the town's own motion,
Yes.
and I take it that the respondent are in compliance?
Yes.
Okay, let me see a proposed order. Is respondent present? Yes, sir. Okay, go up, state your name, state your address, and state that you're in compliance, please. Or that you're in agreement, excuse me.
Yes, sir. Rick Chapels, I work for the Kelsey Group Construction Manager. The address in discussion is 2550 South Park Road, and we are in agreement with the abated fine.
Okay. Repeat the amount, please.
$112.50.
So the fine and the lien, you wanted abated to 112.50.
Yep.
Okay. Standard payment provision is 30 days. Does that apply here? Or is it shorter?
Do it immediately.
Okay. 30 days is fine.
Okay, the respondent knows that if the payment is not timely made within the 30 days and cleared, that it reverts to the original amount and could not be abated again
Yes,
or
sir.
reduced, right?
Understood.
Okay. If you want a copy of the order, you have to wait for it.
Yeah.
If not, the town will mail it to you.
Just give you a copy. Right?
We're good?
That's fine.
Yeah, we'll just pick it up. Thank you.
Yeah. Rick, you have other case, no?
I do. I have one more.
Okay.
I don't have 8 this time, sir, just so you know.
That's an improvement.
Next case is on page 2, section 6.4. Chief Code Enforcement Officer Jocelyn Ramirez. Case 5513. Property owner Park 31st Corp. Site address 1804 Southwest 31st Avenue, Pembroke Park, Florida.
No, a mí no me lo da. Ah, okay, go ahead.
A notice of violation was sent out by regular mail on January 19, 2021. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on May 4, 2022, and posted to the property and at Town Hall on May 6, 2022. At this current time, let me list the violations. Item number 1 is operating without a business tax receipt in Bay 1804A. Second item is unpermitted aluminum metal signs. Owner has to obtain permits for those business signs. Item number 3 is business showroom is blocking mean of egress door. The business owner has to remove cabinets, plywoods, and materials blocking doorway. Item number 4, it was a prohibited banner on 1708 Southwest 31st Avenue. And the banner has been removed. And, but at this time, the tenant does not have a business tax receipt and does not have permits for the signs. So my recommendation is to give the owner 30 days to comply, if not a $250 per diem with a $100 admin fee, and it will be a separate fine for each violation.
So, sir, please state your name, your business address, and if you have any objections to the rendition of this order as proposed.
My name is Rick Chapels, business address for my office, sir.
Yes.
1812 Southwest 31st Avenue, Pembroke Park, Florida, 33009. And I agree with what was read. I would like to respond, though.
What is your response?
I'd like to submit some information. What I submitted, sir, was first was the business tax receipt information form for the primary address for 1804 Southwest 31st Avenue, which is Panda Granite and Marble. They're one of our tenants. They obtained a BTR on the 17th of July of 2007, 15 years ago. They signed a lease for 1804A, which is the adjacent space, on 4/16 of 2015, 10 years ago. At the time, they were told by the old administration they didn't need a BTR because they were adjacent. It was a contiguous space. So, unfortunately, what happened is when, a year ago, when Officer Ramirez rightly noted that they do not have a BTR for 1804A, the business owner was out of country. The individual who took the notice of violation didn't share it with him, apparently. I, as the manager of for the landlord, assumed, which is a bad word, that the tenant was dealing with the situation, and they did not. So what's occurred is, even though they've been there for 10 years thinking they were okay, and they've been in good standing and have a current in-force BTR, business tax receipt, which is the #1 item on the code violation, that BTR is for 1804, not for 1804A. So we're now working through the process to get into 1804A, to expand it, to include that with a separate BTR, business tax receipt. Unfortunately, that process includes inspections. Those inspections took place on 5/12/22, and they failed gloriously, structural, fire, and electrical. So because they failed so gloriously, we now need building permits to fix these failed inspections, which will not be able to be obtained or attained in 30 days. So I'm asking for a minimum of 90 days and a reduction of the fine to $100 a day after that, if possible, because they have been operating in good faith. They signed the lease on 6/13/2007. They were issued the BTR originally on 7/17 of 2007. So less than a month later. They weren't trying to avoid getting the business tax receipt. They just didn't know they needed one. And then we did not pay attention, we, myself included, to the write-up from a year ago. And that is why we're in front of you today. But now that we're aware of it, in the package I also provided a copy of the inspection reports, which show where we need to get the permits. And also, we applied for number 2. We have process number 95823 for the aluminum metal signs, which also have been there for over 10 years. But we're getting the permit. We applied for that yesterday. It's process number 95823. We'll get the permit and get that legal. So I'm just asking for 3 months to obtain plans from an architect, submit for the permits, get the inspections, close this out so I don't have to stand before you mitigating a fine in the future.
Right, well, let me respond from a legal standpoint. I'll always listen to what not just the respondent, but the town as the movement has to say, but my own opinion is that the 250 need not be reduced. I find that the fines here are generally low.
Yes, sir.
In many other jurisdictions are $500. And I think that this particular town is not excessive or extreme, and it's fine. So that request is denied. As for the BTR, I think it's common knowledge, despite any misunderstanding, which is regrettable, that you need a BTR for each separate bay.
Correct.
You know, that is well known to anyone that is in business or in the trade, you know, so.
Respectfully,
whether-
could I say, because the tenant actually came to the town and was told 10 years ago that he did not need one. We had a different I've been here since 2006. So the administrations have continued to change, and I applaud the work that these folks are doing. They're doing a great job cleaning the town up. But we had different people doing the same jobs a long time ago, and they had different interpretation of what was required. And this individual has never shirked this tenant of ours, his name is David. He's never not done something if we've asked him to or if the town's requested it of him. So I really do not believe he's just making it up. I believe 10 years ago he came here and talked to somebody, and they said, no, you don't need one. You already have one. It's right next door.
No, I have no doubt you're telling the truth. I mean, I believe, you know, you strike me as you know, my gut sense is that you know, you are a person of integrity. That's not my point, but that was, he may have understood that then, but a year ago he was cited and was told what the correct thing
Yes.
is, that you need a BTR and a CU for that matter for each separate bay.
Yes, sir.
Or each separate commercial, you know, area that is operating on its own. So the 250 per diem is not going to be reduced for the reasons I said. What about the time frame? Is there is 30 days in the town's opinion unduly short, or is that because of what else is involved, or?
I believe that they had sufficient time. They had a year. It was ignored for a year. So 30 days, I think we're being generous with the 30 days.
Okay. So how many different violations are outstanding here? Because I want to note that still exist right now.
That still exists.
Right, that still exist.
Is
because-
the permits for the aluminum sign. They're blocking the mean of egress in the showroom that they created.
That part has been resolved as of yesterday. So
Okay,
number
then-
3 has been
then
resolved,
they-
4 is resolved.
Then no one called for a
I know,
reinspection.
I've just
Okay.
didn't
So
get there yet.
I will have to reinspect that, make sure it was done. And the BTR, I know that they're in process, but they're not going to be able to get the BTR until those permits are pulled. And I did check the process number 95823. It's only for one aluminum sign. They have 3 aluminum signs on the property.
So when we look at, and I know that one does seem to be resolved pending reinspection, must be verified by reinspection, so I can't presume it's cured.
Well,
So how many does that make in total? Because I want to note that.
It's 3.
and can I explain the sign issue? Since there's separate addresses, 1804, 1804A, and 1802, we're submitting separate permits for the separate addresses. So I only submitted the one that was for this case, which is 1804A. Because 1804 has an active BTR.
1804A is under the same folio number as 1804 Southwest 31st.
The entire building is under the same folio number, yes, ma'am. But the challenge I have is just like, we're kind of going both sides of it. I have a BTR already under the same folio number for 1804, active and has been since 2007. But I'm here in front of you primarily because the BTR and then the unpermitted aluminum signs.
But again, let's be clear, because this part is not rocket science. If you have an address, and let's just say theoretically, you have an 1804 with one business, 1804A with one business, 1804B with another business, and 1804C with another business, each of those needs a BTR.
Yes.
Correct, but this is the same business in 1804 and 1804A. That's the rub.
Okay. Does it make-
1804,
okay, I understand your point. Does it make any difference that it is the same?
No. Because
Okay.
if they expand it to another unit, now they have to apply for that one.
So even if it is the same, let's say it's,
I
the
know
same-
that the business tax receipt department, what they do is to accommodate them, and they'll just have to revise that BTR that they were working on, and they'll put that they're working on 1804 and 1804A. So,
but a separate, I mean, that's my question to you. Is a separate one required for each bay,
yes,
even if it's the same business?
yes.
Okay.
sure, that's
Because
kind of a
that's-
new enforcement. I'm not saying it's a new rule, because I don't know when the rule was made, but I do know that was not previously enforced up until, and I'm not disparaging anybody, and I agree
No,
with you.
I know.
But
Officer
we
Ramirez,
didn't,
right, Officer
we didn't
Ramirez-
do that.
It's
We-
based on ordinance 15-23, which says separate business tax receipt for each business location for each business advertised publicly.
Are you saying that's section 15-23 of the code? I'm going to take administrative notice of section 15-23 of the code, which I'm going to read out. Separate business tax receipt for each business location for each business advertised publicly. No person or business entity shall engage or manage any business, profession, or occupation in this town without obtaining from the town a business tax receipt for each separate location in the town. A business tax receipt shall be required for each business advertising its location in the town sign, newspaper, magazine, or otherwise, and any such sign, newspaper, magazine, or other advertisement shall be considered evidence of conducting the business in the town. The business tax receipt shall be issued to cover one location.
For that particular location.
But it is that advertising, even though it's two different signs, it's for the same business. They're not advertising separate. They have one business in two spaces. A lot of times what will happen is we'll get a permit, we'll put a hole between them, and then it becomes one space, but that, they didn't need to do that. They're small spaces.
So I know, I take administrative notice of the section, which is read into the record. I'm going to note it in the order. My question to you is because the town has, you know, fair amount of commercial enterprises here because, you know, there's a fair amount of commerce in the town. Is it the established practice and procedure of the town to require a separate BTR for each, I'm going to call it mercantile bay or, you know, each sub, that's what I'm just trying to establish that. I
Right.
just want to be,
In the past, the BTR personnel that we have here in this town told me that yes, that they have to apply for that additional unit. So the answer is yes.
so it's your understanding that since you have been here,
Yes.
it has been that way.
Yes.
Okay, and and I'm taking administrative notice of, repeat that section again, I just had it, but,
15-23.
okay.
So-
In light of the testimony from the town representative and a reference to 15-23 of the code, the fine is $250 per day for each violation. And in the sense that, I am sorry, but in the sense that it has been pending a year since you cited them.
Could I say one, before you final, sir, can I say one more thing? Is that allowed?
You can say one final thing, but I've already ruled.
Okay, all right, well.
All right, I've already ruled because I listened to you, but I also listened to the officer's
Understood.
testimony. And you are the person that cited them a year ago, correct?
She did, but we didn't get the inspections requiring permits until 5/12 of '22. I just got this from the town yesterday at noon when I requested it because I happen to know who to call to get it. So there's a system here that's separate from building permits and everything else with the BTRs. And it's very difficult for the tenants, my customers, and myself to sometimes see into that system to see what's required. So yes, we knew about the case. Yes, we were working on it. We made a bad decision to not look further quicker. But when we did get the BTR application signed, submitted for 1804A,
You said
got
it,
the
I mean,
inspections.
you said it yourself, but again, this is not,
But
this
Okay.
is not like Miramar or Pembroke Pines. This is a small town.
Right.
You are here, you could have come here, you could have, I thank you, but that's not going to carry the day with me because of what has been heard and what I just said to you.
Yes, sir.
So that's the order, and thank you for coming in.
Thank you for your
30
time.
days, 250.
Got it.
Hang on for your copy if you want one, please. Yes, sir.
Next case is on page 6.
Yes, hang on a minute. What docket number does it have? Because on the screen, the page numbers don't, what's the docket
Oh,
number?
it's section 10.2,
10.2?
case 5549.
It's the last case on the docket, in other words. Yes, okay, go ahead.
Chief Code Enforcement Officer Jocelyn Ramirez for the town of Pember Park. Case 5549, property owner VNA Miami LLC, tenant Anoints Body of Christ. Site address 4400 West Hallandale Beach Boulevard, Pember Park, Florida, Unit 6. A notice of formal hearing to extend time was sent out by certified mail on May 5th, 2022, and posted to the property and town hall on May 6th, 2022. The violations were for operating without a business tax receipt and tenant build out without a permit. At this current time, BTR has been applied for, but it's still in process as of September 24th, 2020. And there is a process number for the tenant build out in the building department, 95098. It is the owner's request to extend this time for this violation to comply. So my recommendation is 30 days, if not a $250 per diem with a $100 admin fee.
So 250 and 30 days is your recommendation. There's somebody here from the respondent? Please give your name, your business address, and tell me if you agree.
My name is Claudine Thorpe, 4400 Hallandale Beach Boulevard, Unit 6. I would like to request a little more time because we're just changing contractors. I came to the city to find out what's the holdup taking so long. I know Miss Jocelyn been very patient with us. I've been trying my best to get this paperwork done, but the contractor wasn't doing the plan and putting the paperwork with the city. That's why I'm requesting a little more time.
No, and look, I'm not, I hope I'm not unduly severe, but, just like, a tenant misunderstanding something, just like a contractor not being diligent is not the town's fault, but I understand what you're saying. Do you think in light, Officer Ramirez, of the totality of the circumstances, what they've explained, and your personal knowledge of this, that 30 days is sufficient, or are 45 or 60 days, in your opinion, viable here?
I believe that the town has been generous since this violation has been open since February 25th, 2021.
Okay. Taking administrative notice of the fact that the violation has been open now for 1 year and 3 months, in other words, 15 months, and having my recollection reflected by the town on that, I think the 30 days is more than reasonable. So it'll be 30 days. You better speak to your contractor, because again, this has been pending for 15 months. So in another 2 months, it'll be a year and a half. Is this very complex, or is this fairly to correct?
There's always hurdles with contractors. So each case is different. Depends who you hire. So I can speak for in general.
All right.
Some people get it done quickly. Some people don't,
I think that, ma'am, I'm mindful of, but this has been going on for over a year. You need to speak to your contractor and say that the town is, becoming anxious with you reaching compliance or cure for this. So you'll have 30 days, and if not, it'll be $250 a day. I am sorry about that, but, my experience here is everybody always wants more time. Sometimes it's warranted, sometimes it's not. But the thing with the older cases is there has to be closure. The whole idea of code enforcement, it's not revenue, but it is compliance. So the cases just can't stay, because, the cases need finality. There needs to be compliance. Okay? That's the order. If you want to wait a minute, you can get a copy of it. Thank you for coming in.
Thank you.
Next case is section 9.3.
9.3. Okay.
Chief Code Enforcement Officer Jocelyn Ramirez for the Town of Pember Park, case 5485, property owner Park Lake Inc., site address 426 Marine Drive, Pember Park, Florida. A notice of formal hearing to abate fine was sent out by certified mail on May 4th, 2022, posted to the property and town hall on May 6th, 2022. This matter is here today to abate a fine of $3,100. It is this town motion to abate this fine by 15%, a total of $465.
Abate the fine to 15% of the amount due, to $465. Is that what you, I just want to be sure that, okay. Sir, please give your name, your business address, and if you agree with the recommendation.
Good morning. My name is Bertrand Cesset. I'm the general manager of Park Lake Estates. The address is 3184 West Hallandale Beach Boulevard. And yes, I agree with the decision.
This is, here, okay, I think I understand. It's Park Lake Estates, but the named persons were Janet Bonner. Is that correct? Is that why?
The name is Park Lake Inc.
Janet Bonner is the owner of the house.
Janet Bonner is the owner of the house, but this was done on the land. The work was done on the land, so the
I think that what we're going to have to do here is the town will have to, the correct respondent here, which appears as Janet Bonner, is actually, it's Park Lake Inc., right? Mm-hmm. That is the correct respondent.
yeah.
So the order is going to have to be amended. I will sign it.
Okay, Nasli will correct it. It's
You'll
not a
have to
problem.
correct it and mail it out,
Yeah.
okay? So the fine is abated to $465. Is it 30 days or
Is 30 days sufficient?
That's fine.
30 days? So if you know that the rule is that if you do not pay the full amount within 30 days, that it automatically reverts to the original fine, and there would be no other reduction from me anyway.
I understand.
Okay, so the order has been entered. The first page of the order, I note for the record, has to be corrected to reflect the respondent as Park Lake Inc. and not the owner, Janet E. Bonner and Janet E. Bonner Trust.
Right.
And esto es todo lo que tiene que ser. All right, thank you.
Thank you.
The order will be mailed to you.
Copy, Joss, or no?
You can give them a copy of that, but you're going to have to revise that order.
Yeah, just give him a copy and we'll send the corrected by mail. Next case is on section 6.10.
6.10. Hallandale 5220 LLC, right?
Yes. Chief Code Enforcement Officer Jocelyn Ramirez, case 6727. Property owner Hallandale 4520 LLC. Site address 4520 West Hallandale Beach Boulevard, Pember Park, Florida. A notice of violation was sent out by regular mail on February 8, 2022. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on May 3rd, 2022. Posted to the property and town hall on May 6, 2022. The violations were for exterior roof facades that have dirt built up. This was complied. Dead palm tree. The dead palm tree was replaced. Prohibited banner signs. All banner signs have been removed. Prohibited digital signs. Digital signs still remain at the property as of yesterday, so May 17.
The digital signs have not been corrected.
Right. Prohibited neon signs and lights. As of yesterday, there's still some that remain. Installation of electrical cameras without a permit. This, there's a permit pulled. Still don't know if final inspections were completed. Exterior maintenance of common areas required. Pressure wash sidewalks, steps, or any pathways. This item has been complied with. Monument sign is faded and rusted. Maintenance required. Wash, repair, and paint. Some work has been done, but the monument sign, we addressed it yesterday. It still needs some work to be done. Item number 9 is prohibited signs, snipe signs. The snipe signs have been removed. Item number 10, multiple businesses operating without a license. I noted here CAM, Just Insurance, Beauty Supply with U-Haul.
Various don't have a BTR, it says here.
Yeah, various tenants don't have a BTR. Optical, Rosso, so BTR is incomplete. Falanchi Boutique, Natalia Studio Spa, they don't have a BTR. So upon investigating, Rosso still has no BTR. Optical, no BTR. Just Insurance, no BTR. Falanchi did obtain their BTR. Natalia Studio has moved from the unit. Beauty Salon, they have BTR and have removed the U-Haul service. Item number 11, abandoned vehicles on the property. This has been complied with. Item number 12, parking lot has multiple stripes and does not follow the zoning code. Obtain plans, permit, and inspections to pave and restripe. A permit was pulled for this. Still not sure if the final inspections have been completed. Prohibited for rent sign. For rent sign is not up to code. This has been corrected. The sign has been removed. Item number 14, tenant build out without a building permit in Unit 11. Obtain a contractor to obtain plans for permanent inspections. That's the unit that was vacated. The tenant moved without notice, but the property owner still has to obtain a permit for everything that was removed, an after the fact permit. Number 15, Enchanted Candles channel letter sign was removed without a permit. A permit has been pulled. Inspections are pending. Item number 16, installed multiple change of copies on monument sign without a permit. There are multiple signs on the monument signs that still doesn't have a permit. I believe the property owner only pulled 2, so they still have to. It is about 10 signs on them, on each side of the monument sign. So they have to.
Signs on each side of the monument?
Yeah, you know how they have the little sliders.
Oh, that little, right, oh, yes, yes.
So they
no,
have
right,
to
okay,
get
right. The
a
ones that slide
permit
it, yes.
for each.
Yes,
So there's
yes,
like
I
about 10
right.
on each side.
Yes, I understand. And they need an approval for each of those slide slots, correct?
Correct.
Yes.
Item number 17, remove abandoned signs from business no longer there with demolition permit. So that has been in the works. I believe those are the permits that they obtained. Item number 18, prohibited sandwich signs. All the sandwich signs have been removed. Item number 19, all windows must have visibility for public safety. Remove any sign, structure, items, or tinting that impairs visibility. The code only allows for windows to be covered by 25% per window. That is in progress. A lot of signs have been removed from the window, but there's still some that remain and that they're working on removing them. Overall, the property owner has got it from 19 items. They have gotten a lot done.
And how many, do you believe that property owner is acting in good faith, or?
They're acting in good faith, so I'm recommending 60 days to complete the rest, if not a $250 per violation.
And with that, and you were very descriptive in your narrative of violations, but there were such a numerosity of violations. How many are still outstanding? Because I want to make a note of that, because I realize various were corrected, but certain ones were not.
Right. Let me do the math here right now. About 8 left.
About?
Yeah.
There are 8 left.
8.
The rest have been cured.
Mm-hmm.
Okay. Anything else at this moment?
No.
Miss, please give your name, your business address, and then state what you want to say about this matter, about this case.
Veronica Perez, 4520 West Highland Beach Boulevard. She's right about what she's saying. And then the 8 points that is still remaining, most of them are the permits. The parking lot, we finished it yesterday. We have zoning inspection. We passed inspection. So I think there is another remaining inspection. I'm not sure about that.
You're saying that one of those violations has been corrected as of yesterday, but
No. I'm talking about the permits. Like most of the, like the 8 remaining point, 5,
Right.
it may be the permits that are open. We passed inspection from the cameras yesterday. I have it here if you want to see it.
do you want that submitted? Normally, typically, look, I want to defer to the town as to what the town's practice is, but typically in the code enforcement compliance, the inspector, whoever is involved, has to come back out and confirm. It's not that anyone doubts your word, but, owners have their own interests. You want?
I can look at it tomorrow because you do have a lot of permits that were pulled.
Yeah.
If you want to meet with me tomorrow, we'll go one by one and see all the permits that have been completed.
Okay. Yeah.
Do you want to introduce that into the record? If you want it in the record, you would need to introduce it. And if you just want to meet with her about it, that's up to you. I'm just telling you.
I actually sent all the copies by email yesterday, so you may have all the copies.
You sent her all the copies yesterday?
Yeah, I sent it to all
Okay.
the code enforcement.
Right. Well, I don't want to
Jeffrey.
advise you, but do you want to put that in the record?
Sure, yeah.
All right. Well, then, you're familiar with what this is?
Yes, those are the permits that were pulled for some of the works that I mentioned.
Camera system, parking lot. After this fact, removing demolition of the sign, That has two parts, one
Okay,
electrical.
show them to her, and if she has no objection, they'll be placed in the record as your exhibits, as your composite exhibits, for future reference in case this matter somehow comes back. Hopefully not, but
This is the electric for the demolition. Change of copies.
Okay. All right, it has been entered into the record.
okay. Those
They're your original copies. All right, I'm gonna give it back to her. No, it's okay. That's what I'm saying. Like, I'll check it in the system tomorrow.
So do you want to submit? Do you want to submit it or not?
Those are original files, so she'll keep them. But I took a look at them.
I don't know if you want to make copies, or she may have it on the.
We have these.
No, the point I'm trying to make so you understand is, as I said at the beginning of the hearing, if you want any document in the record, you're responsible to place a copy in the record. Whether the town wants to make a copy or not, I don't control them, but you.
Nasli, can
if
you make a
don't place
copy
it in-
for her?
What?
So Nasli will make a copy, so it's entered in the record,
Right.
and she
It-
can keep
It
her
can't be in the
originals.
record unless it goes into the record, okay, is what I'm.
Regarding to the other copies, I only pulled 2 permits. I didn't know that I needed to do the entire. We talked about that yesterday, so I'm gonna do it now. I'm gonna get 1 permit for each sign. I didn't know it was not. I started working on the property just when we got the valuation. They told me, take care of this. So I'm trying to do my best and do it quick.
Can you speak a little bit more into the
Sure.
mic, because I'm having a little difficulty clearly hearing everything you're saying.
Okay,
Speak a little.
So yeah, I started
Yeah.
working at the property
Yes.
when we got the valuation.
Yes.
So I'm trying to do everything as quick as I can. Thank you.
Okay.
She's done an excellent job so far.
Okay. You know, there are, per the records of the town, there are 8 violations that remain. My order is going to provide that you have 60 days, you have 2 months
Okay.
to comply.
Okay.
Now, I want you to clearly understand what that means, that seems that you've acted, actually, I want to commend you, very proactively in curing these things, more than many others who appear before us. So you're to be commended for that. But there are 8 violations outstanding. You have 60 days to correct them. If not, there will be a fine of $250 per day after those 2 months per violation.
Okay.
You understand?
Understood.
So you have to continue to be diligent and to be proactive with the contractor, your workers, and anybody else you have engaged in this. To be sure that they are all corrected within that time. There is, for any case that comes here, a $100 administrative fee for every case. It's
Okay.
so this is what the order provides. If you want to wait a moment, they will give you a copy.
Okay.
And do you have any questions?
No question.
You understand?
Yes.
All right.
Thank you so much.
Thank you for coming in, and thank you for acting proactively. We'll wait a moment. We'll wait a moment now. Yes.
Next case is on section 6.13.
6.13. Trinity Broadcasting?
Yes.
Yes, okay.
Chief Code Officer Jocelyn Ramirez for the town of Pembroke Park, case 6941. Property owner Trinity Broadcasting of Florida, Inc. Site address 3300 Pembroke Road, Pembroke Park, Florida. A notice of violation and a notice of formal hearing was sent out by certified mail on April 14, 2022. Posted to the property and town hall on April 14, 2022. The violations were for demolition of structures without a building permit for lot T28, T47, 148, 228, 240, 319, 322, 423, 427, 429, 440, 447, and 450. Also, item number 2, prohibited flag banner signs. At this current time, they have removed the flag banner signs, and they have pulled permits for T28, T47, 148, 228, 240, 319, 322, 423, 427, 429, 440, and 447. They're still pending permits for 447 and 415, and they're pending inspections for the other permits that they currently have. It is my recommendation, since this is a repeat violation referencing case 5364, I entered the final order into the record.
I take administrative notice of case number 5364, and the final order is deemed admitted into the record as to a finding of this same violation occurred at the same property with the same owner in the past.
Yes.
Okay.
I'm going to recommend 30 days to complete the inspections and those 2 other permits that they need to pull. If not, a $500 per diem with a $100 admin fee.
And how many, I'm going to ask you this, officer, when we're reviewing cases where you have testified to numerosity of violations, how many of these violations that, because it's said fairly quickly for me anyway, how many of these violations are still pending, outstanding, that is not cured?
2.
2?
Lot 447 and 450, they currently don't have a permit for those. And then the other ones, all the other lots that I mentioned, let me see how many are there in total.
Yes, that's what I'm looking for, the total.
So there's 13 in total. And so they're working on getting the permits for 447 and 450. So really and truly, they have only 11 permits pulled, and they have to complete the inspections for those. And these are after the fact permits, meaning that the work has already been done. You just have to get the permits and complete all
They have
inspections.
to get the after-the-fact permit, or the work has to be undone, one of the 2, right?
No, the work already was done.
What I mean is, if the permit is not granted, the property must be restored.
Well, in this case, they were all demolitions. So
There were demolitions, okay,
Yeah.
all right. So, again, the total, as to what, give me just a total.
11. Okay, so I'm gonna say 13 is still incomplete because they need to
Okay.
complete the inspections.
So 13 violations are not fully cured, not,
No,
well,
yeah.
you're either cured or not cured, actually, that's a
Exactly.
misnomer, right?
So not cured.
Not cured. Is there anything else you want to say at this moment? Sir, please give your name, your business address, and tell us what you want to say about this matter.
Good morning, Enrique Fernandez, and it's 3300 Pembroke Road. The two that were pending, that we haven't pulled permit, is because it required an asbestos survey. The asbestos survey has been done already. We're just waiting for the lab results for any amendment that we have to do, if we have to do none to those two. The process for the permit has already been submitted, pending the asbestos survey. But 30 days is fine. We should have all this closed in the next couple of weeks.
All right, I appreciate your candor. By the same token, I want you to know that I'm going to note that this is a repeat violation. Per prior case 5364, which is administratively noticed. You know what that means? I think you do, but let me briefly explain. When a violator has done the same violation on the property in the past, the fine doubles. In some cases it triples, but in this case it doubles. So
Can I say something, Special Magistrate?
yes, you may.
I know what we were not aware of what happened in the past. We just took over this project a month ago. This project is in the process right now to be demo completely. Tenants are leaving little by little. As they leave, we're going to go ahead and demo, remove trailers. So this is not going to be an issue that's going to happen again. You know, there ain't going to be no more tenants doing anything there to any of those units, with the exception of us on the construction side demoing these units, taking them out of the lots.
Well, let's hope so. But again, per your testimony, the same respondent, Trinity Broadcasting of Florida, Inc., committed the same violation on this property in the past. Okay, so based on everything that we have heard, please be diligent. You're going to have 30 days from today's date to close out these violations. And there are 13 violations not corrected as of this date. You're going to have to move quickly on all of those. If not, because, again, I've made a finding that you're a repeat violator. Not you personally, but the property doing the same thing with unpermitted work. It's going to be a $500 per day fine per violation. So to avoid that, please act diligently. Please remain and get a copy of this order, if you would, please.
Well,
Thank
they have another case as well,
They have another case, so let's hear their other case.
which is 16 on section 6.14.
Okay, hang on a minute. You may want, right, okay. You can go ahead here.
Chief Code Officer Jocelyn Ramirez for the Town of Pember Park, property owner Trinity Broadcasting of Florida, Inc., site address 3200 Pembroke Road, Pember Park, Florida. A notice of violation with a copy of the notice of formal hearing was sent out by certified mail on April 14, 2022, and posted to the property and town hall on April 14, 2022. The violations were for demolition of structures without a building permit for lot 931, 840, 820, and 613. At this current time, they have pulled permits for 840, 820. They still need a permit for 931 and 613. In addition, they also had the violation for prohibited flag banners, but these flag banners have been removed. It is my recommendation to give them 30 days, if not a $500 per diem with a $100 admin fee.
And are you relying on the same case 5364 to make them a repeat violator
Yes.
in this instance?
Yes. And the order has been entered into the record.
Nothing else further at this moment? How many of these violations on this particular case remain pending?
4.
Okay. So you're making the same recommendation as you did in the other case?
Yes.
Again, please give your name, your business address for the record, and tell us what you want to say.
Enrique Fernandez, 3300 Pembroke Road, Special Magistrate. We're in the same situation with these violations. The 2 that are pending is because of an asbestos survey, which has been done already. The other 2, we have permits already. And the work has started already. So we should be finished with all these violations. No further, maybe in a couple of weeks, we should be final inspection. So the month is fine, more than enough.
Well, please act diligently, because here, even though it's not you, the code enforcement violations really have to do with the property more than, so even if someone else in the past did something, it was on that property by Trinity, so you're deemed a repeat violator, which means the same thing happened in the past with the town with the same violation. So that is why the penalty is enhanced to $500. So here, we're going to be uniform and say the same thing as we did in the other one. You have 30 days, but please be diligent, because again, the idea is compliance, not revenue. But again, note that if in 30 days, you must act very promptly, because if not, it's $500 per day per violation. Am I clear?
Yes, sir. Now, on the 4 that we need the asbestos survey, is there any way, because if it's asbestos and there's any finding, it might be a process. It might take a little bit longer just for those 4 units. Is there any way for those 4 units with asbestos, can you give us 60 days in case we run to any issue with asbestos? Only for those 4.
Well, one thing I can tell you legally is that I don't, and we don't in code enforcement bifurcate the cases. We can't say this for that and that.
Right.
It all has to be done in a uniform way. Now, whether in light of that the town wants to revisit the 30 days, I defer to the town on that. I
believe that it is a lot of units that they have to complete inspections for all of them, and in Broward County, I've heard that it's slow. So, I mean, I wouldn't be opposed, but I think it's okay for 60 days, but for not, are you asking for both cases or just this particular one?
It's both. No, it's both, because they have asbestos. On both cases, we have units with asbestos. I know in the next week or a couple of weeks, the work has started already on the other units that doesn't have asbestos, and that's going to be close. I'm going to call my inspections. for electrical, for plumbing, and for building, probably next week, and I'll close those. My only concern are the ones with asbestos. It's a process. It might take a little bit longer. We still got to present the survey to the city. We still got to get a permit. The rest of the stuff has been issued for those units already with the city. It's just a matter of the asbestos report.
Okay. Miguel, can you give your opinion on this matter since you work with Broward County and permits all day long?
Yes, you need to come up to the mic, identify yourself, give your title, and give an opinion, because the issue here is simply whether it's 30 days or 60 days in light of what has been heard.
Yes, Magistrate. My name is Miguel Nunez. I'm the township building official. What they need is, this is for the lakeside RV removals. All they need from is the asbestos certificate from Broward County, which is considered also a 2-3 day process because it's residential. We're talking about the statement regarding responsibilities regarding asbestos. Basically, that's what it is. I think 30 days will be fine. They should be able to do it without any problems.
30 days should be sufficient.
Based on the testimony of the building inspector, and let's just hope that that is accurate, I am going to leave it at 30 days because according to the building inspector, the building official, actually, this is a simplified process for this. This is not like I'm thinking of asbestos removal in a building where you need a separate procedure to, this is not that.
No, sir, there's no abatement, especially because it's residential. For the most part, it's just a statement regarding responsibilities asbestos. It's online process. Sometimes they charge $50 or not, but it's very, very fast. We have done it a million times here in the town.
And you're certain that that is what is applicable here, not the asbestos.
That is correct, sir.
So in light of that testimony, it's going to remain at 30 days. And please act diligently, and you can get a copy of the orders now. And note.
Thank you.
Thank you. Thank you for coming in. Hang on one second.
Good morning, Mr. Magistrate.
Yeah, good morning.
Agenda item 7.9. This is going to be case 6893.
7.9,
Yes, sir.
okay.
Property owner identified by Holiday Hollandale Mobile Home Community LLC.
I'm
Site-
sorry, if you did already, I didn't hear it. Code Enforcement Officer, please give your name and your rank, please.
Yes, I apologize for that. Code Enforcement Officer ERIK Richwagen, representing the town of Pembroke Park.
Okay.
I'll say it again. Agenda item 7.9, case 6893. Property owner identified by Holiday Hollandale MHC LLC. Site address 3140 West Hollandale Beach Boulevard, Pembroke Park, Florida. Just so you know, I am going to read off the violations fully. That way the scope and magnitude is understood of this particular case. Is that okay with you, Mr. Magistrate?
Yes.
Okay. First and
The
foremost,
is the respondent here? Yes. Okay. All right. I just wanted to.
the notice of violation and the notice of formal hearing were both issued on 3/30/2022, and they were both certified on 3/31/2022, and the violations were posted to property and posted at City Hall. As for the violations, as followed, Holiday Hollandale MHC LLC is in violation of Florida Statute 320.8325, a mobile home or park trailer manufactured in accordance with the code standards and labeled hurricane and windstorm resistive shall be anchored to each anchor point provided on the mobile home or park trailer. A mobile home or park trailer which does not meet these standards must be anchored with the anchor points spaced as required by the department starting at each end of the mobile home or park trailer. Holiday MHC LLC is in violation of the Town of Pembroke Park Ordinance, Section 28-285.5.
I'm sorry, repeat that?
The whole thing, Mr. Magistrate?
No, just the town ordinance part.
The town ordinance is Section 28-28.5. Tie-down requirements for permanent location status vehicles. Any,
That's chapter 28/28.5.
yes, sir.
Okay.
Yeah, 28/285.5. Any recreational vehicle granted permanent location status shall be tied down in accordance with the standard applicable to mobile homes for such purpose. Ordinance number 00-4-4, 17-4-26-00. The following lots are in violation of this particular section. I'm not going to go over in each individual one, so I'm going to kind of abbreviate it. So it'll be lots 12 through 20, lots 120 through 122, lots 221 through 236, lots 327 through lot 333, lot 423 through 436, lot 513 through 533, lots 601 through 615, lots 713 through 722, 802, lots 914 through 916, lots 1001 through 1013, lots 1102 through lot 1130, lots 1132 through 1201, lots 1301 through 1335, lots 1310 through lots 1334, and lots 1401 through 1433. Also for the entire mobile home park itself, Section 28-25.4, permanent location, application and fee. Any recreational vehicle owner desiring to obtain permanent location status may do so by filing an application on forms promulgated by the town and pay an initial application and inspection fee as established by resolution of the Town Commission. Every permanently located recreational vehicle will be inspected annually by the town to verify it is in compliance with the requirements of the town's code of ordinances. The owner of any permanently located recreational vehicle shall pay the town an annual inspection fee as established by resolution of the Town Commission. Section 28-264, recreational vehicle site dimensions. Every recreational vehicle site in an area designated in a mobile home park for occupational and recreational vehicles shall not be less than 1,000 square feet in area and not less than 30 feet in average width. Section 28-267. And I will have to read off the subsections just so the full understanding is understood. Distance between structures. Alpha, no part of any living area within a mobile home or recreational vehicle may be placed, constructed, or maintained within 10 feet of any other living area of an adjacent mobile home or recreational vehicle. Bravo, no non-combustible accessory structure may be placed, constructed, or maintained within 3 feet of a mobile home, recreational vehicle, or accessory structure located on an adjacent mobile home lot or recreational vehicle lot. Charlie, no combustible accessory structure may be placed, constructed, or maintained within 5 feet of a mobile home, recreational vehicle, or accessory structure located on an adjacent mobile home lot or recreational vehicle lot. Delta, no part of any living area within a mobile home or recreational vehicle shall be located within 10 feet of any service building or structure used in connection with the operation or maintenance of a mobile home park. Echo, no non-combustible accessory structures shall be located within 3 feet of any service building or structure used in connection with the operation or maintenance of a mobile home park. Foxtrot, no combustible accessory structure shall be located within 5 feet of any service building or structure used in connection with the operation or maintenance of a mobile home park. Section 28-285, attachments of structures, additions, give me one second, I'm trying to pronounce this word. Appurtenances. Thank you, Mr. Magistrate. To recreational vehicle prohibited. Alpha, it shall be unlawful to attach any structure, addition, or aperture to any recreational vehicle located within town. Bravo, there shall be no addition or attachment to recreational vehicle located on recreational vehicle lot or non-permanent mobile home lots except for a demountable canvas awning. Subsection to Bravo, Charlie, the provisions of subsection Alpha shall not apply to any recreational vehicle when said recreational vehicle is parked or located on a full-size mobile home lot in a mobile home park and is tied down in the method required by this code and Florida statute. As same applies to the mobile homes and is attached to the water distribution system, wastewater collection system, and electrical distribution system as required for mobile homes under this code and Florida statutes. Section 28-28.1, size restrictions for parking on recreational vehicle lot. Alpha, it shall be unlawful to park, cause to be parked, permit to be parked, locate, cause to be located, or permit to be located a recreational vehicle that exceeds the width of 8 feet or a length of 40 feet on a lot designated as a recreational vehicle lot. Bravo section. For purpose of this section, the measurement of the width or length of a recreational vehicle shall include any appurtenance attached to any portion of any recreational vehicle except portable awnings, and shall further include any expanded or pull-out portion of such recreational vehicle. Last section, section 28-285.3, minimum space between vehicles. There must be maintained a separation of at least 10 feet between all recreational vehicles parked or located within the town, either on permanent or non-permanent sites. My recommendation is 30 days, and I'm asking for a fine of $250 per violation per day, with an admin fee of $100 be assessed. At this time, this concludes my testimony for case 6893.
Officer, how many different violations are there pending here? Because you read out, yeah, you were quite eloquent, but you read out so many that I'm afraid I lost track of.
Bear with me for a few moments. There are a lot, so give me one moment.
I could answer that if you like.
If you would, that would be appreciated.
Okay, my name is Marlene Hernandez. I'm the general manager at
Hold on,
3140.
ma'am, give me just 1 second.
We'll hear from you in a moment.
Okay.
Back, okay.
282.
282 violations?
For the lots, there's 282 lots. Bear with me for one more moment, Mr. Magistrate.
Count the ordinance.
Oh, the ordinances. I was trying to count that. Yes, we're going with 282.
Unspecified.
Repeat that?
It'll be 7 ordinances for 282 lots.
So we're I take judicial notice of the ordinances 28, 28, 28, 264, 267, 285, 285.1, 285.3, 285.4, and 285.5. So, if I'm understanding this correctly, I'm gonna summarize it because it was very good but somewhat technical. This is a serious public health and safety violation because various mobile homes are not anchored as required by law, are in too close proximity to one another as in violation of law, and are too densely positioned on the properties.
That's correct.
So the violations here, because of the number of lots, and per the code, each lot with each violation is treated separately, correct? So when you've had, I'm going to listen to you, I just need to understand this myself. When you've had multiple violations on mobile home lots before, which must have occurred because there's various, have you treated the violation separately for each lot? That's what I want to know.
Okay. In this particular case, we have, but based on each case. So if it's this particular lot, we're writing for additions and things like that, yes. But in this particular situation, it would be the mobile home park who's getting cited for not following the ordinance and sectioning the lots as they should per ordinance.
So in light of that explanation, which I understand, what I'm looking for is, and just so you know, I'll be looking for this anytime there are multiple violations. I need to know, for purposes of calculation, how many violations still exist in terms of which will trigger the fine.
Yeah, as of today's date, with no reinspection that's been called in, will stand at 282.
And that, again, that complies with your past practice and the way you have enforced these regulations with the mobile home parks.
Yes.
Because I want to act uniformly. I
Yes.
don't want to act in a different way than, correct? Okay,
That's correct.
all right. Anything else at this time?
At this time, that concludes my testimony.
Okay. Please let your name, your business address, and let us hear from you, please.
Hi,
Hi.
my name is Marlene Hernandez. Property is Holiday Mobile Estates. Address 3120, 3140, West Hollandale Beach Boulevard. Okay, first of all, we don't have 282 sites. We have 254 sites.
Marlene, can you please put the mic down and speak into the mic?
Okay. So we don't have 282 sites. We have 254 sites. We have 123 RV sites and 124 mobile home sites. In the mobile home sites, we have 100 mobile homes. We have the rest of 30, I believe 30 sites, correction. 30 sites are empty sites which have RVs. Now, according to all these violations, the whole property is in violation. How would I, or how would he know that these mobile homes haven't been tied down like they've been skirting, that they haven't been tied down for, you know, for the last 20 years they've been there? On the
You can testify, but you can also ask questions. So I'm not going to ask questions for you, but if you have a question for staff, you can ask questions.
Okay. So Eric, did every mobile home on the MH side, were they inspected to see if they had tie downs?
No permits have been pulled for the tie down, so that's how we know all of them are in violation.
20 years ago? Because these been here 20 years.
Yes, correct. No permits have been pulled.
In 20 years, they haven't gotten cited till now, that they don't have tie downs?
I can't speak for the past. I can speak for what I'm presenting. When looking through the system, no permits were pulled.
Okay. So why is the property, if they're individually owned, why is the property getting cited for and not the owner? Because when they do additions and stuff like that, they get cited, not us.
The owner also gets cited, but also some of these additions are now encroaching onto the common
I'm
areas.
not talking about the additions right now. I'm just asking, I'm going step by step. On the tie downs, they're responsible for tie downs. Like you're giving us paperwork right now for the RV section to get tie downs. We got the forms, and we're going to try to push every RV person there to get the tie downs, right?
Mm-hmm.
But on the other section, they're individual homeowners. So they, just like if they're doing an addition, they should be getting the violation for those tie downs. Correct?
Well, here's the thing. There's RVs that have additions that have been modified.
That's a different, that's
No,
even another
they're still deemed RVs even with additions, but the additions now go onto the common area.
I know, but you're stepping on the other thing. I'm trying to figure out the mobile home section, why the owners are not getting.
Mr. Magistrate, can we actually pull up the pictures? Because I believe the pictures will help clear this.
I know that the RVs on the RV section, there's 12 of them.
Well,
where
I
they
think the
did
pictures,
additions.
what I'm directing staff to do is to show the pictures on the screen.
Because
Yes, I can see it, but I think you need to show them to her.
Yeah.
You need to give her narration of the
Yes.
pictures. Okay?
So that one right there, if you scroll back up to the orange one,
Yeah, lot number
Up.
425.
yeah, this a little more down,
The other one.
a little more down. Oh, no.
That
Right
one.
there. So that is a RV with an addition on it, but it is still considered an RV. You want scrolling? RVs with no tie downs.
Yeah, and 55 of them are not there. They left. They're for the season.
Yeah, when this was cited from that date till today, I wasn't notified or called to do any re-inspections. That right there is also an RV. Or at one time,
At one time, it has a mobile home sticker.
it's still an RV.
Okay. All right,
Does-
so I get what you're saying, okay? We're here to try to make it work,
Yes.
but there's 30 days. There's impossible to get 200 because this is stuff that happened 20 years ago. There's no way in 30 days that we could get people to do tie downs because I got to get lawyers involved now. So on the RV section, what we're going to try to do is get those forms for tie downs, bring them in. And so like that, not people come in, we'll try to get our residents to do the tie downs, bring in the applications, and then do whatever permits or whatever we need. But on the mobile home side, we're going to have to go legal with those homeowners.
Understood. Mr. Magistrate, for my recommendation, I would actually like to change it in light of what she's saying. I believe 30 days is too little. I will recommend 90 days. I believe that'll be helpful. Is 90 days more?
More than, yes. Thank
Okay.
you. And I will come with you guys and let you know as we progress on the process.
You have my card,
I
correct?
got everything.
Okay, all right, just making sure.
Okay, so, I mean, I'm gonna find, to me, on occasion, we hear from owners that, 20 years ago, this and that happened. That's really, with all due respect, and I say this just as in a matter-of-fact way, that's not relevant today, because the fact that there was a violation in the past and that the town didn't pursue it doesn't matter. If there's a violation now and they cite it, it's still a violation. I mean, the law is not going to excuse that because someone didn't do something in 2002 or whatever,
I agree.
I do want to understand because I'm listening to her testimony, which at least as to the amount of the lots and things like that, I think is credible because she's the manager. In terms of how many violations exist, how many lots are there? Because according to her, it's 254, and 30 sites are empty, though that doesn't mean, I guess they were empty when you cited them, but I want to be sure that I don't overstep it in listing lots that are beyond what is actually.
Well, Mr. Magistrate, understanding what she's saying, remember, these lot dimensions are not correct. You have, RVs that are, violating the distance, so there may be cited and stated that there's a certain amount, but due to the proximity of them, I believe the statement is still accurate. If we go out there and do a full walkthrough and something else is found, but with the amount of violations and with the fact that the lot sites are incorrect, even though she's saying, I believe you stated how many.
I could give you a map and you could count them.
Yeah, based on this map, like looking at the map, when you would count it up, it sounds accurate what you're saying. However, because if you look through the pictures, you'll see that RVs and mobile homes on lots are within, too close a proximity. That already is violating what this is showing. So I'm going to have to go with what I originally stated as 282. Do you need this back, by the way, ma'am? Or can
No,
I-
you could keep.
Okay.
All right,
You have it for your
Do
record.
you want to
that'll
submit
be
this?
admitted into the record
Yes.
as an exhibit from the respondent. Is there anything else you want to say at this time?
No, like I said, I don't mind taking care of the violations, and I know what you said about the 20 years.
Right,
But it's a
not
lot for
it's not
us.
relevant.
Yeah, it's a lot for us to, and he gave us 90 days. That's perfect, and we'll work it, and we'll be in touch every time something is becure. We'll let them know.
I want you to please be diligent with, I want you to please be diligent with your correction and your cure, because, so you're going to have 90 days to correct it, 3 months, but it's $250 per day after that if regrettably you are not corrected for some reason, and it's going to be per violation. So I'm going to say that at this time there appears to be violations on 282 lots. So that's 250 times 282. I am going to add that this number is to be confirmed by the town.
Yes.
You said 250 per 282?
Yes.
No, it's per violations. There's 7 ordinance that's been violated. But
Okay, but I thought that I misunderstood. I thought you wanted to treat each violation separately. Okay, so
it's a separate fine per violation.
I understand. So I'm going to make a note that I misunderstood that then. My apologies. There are 7 separate violations per the town code sections cited. In this order. And so to be very clear, I'll put 250 times 7. And as I said, I misunderstood that. I thought you were treating each lot as this.
Yeah, Mr. Magistrate, if you look in the final order, it does have the verbiage down toward the bottom.
In addition to the fines assessed by the, shall pay a per diem for each day the violations continue to exist. A separate fine of $250 per day shall be assessed for each of the above listed violations. And the above listed violations are 28264, 28267, 28285, 28285.1, 28285.3, 28285.4, and 28285.5.
That's correct.
And I note that it's clear to me now, no matter somehow listening to the individual responsibility thing, that whatever, it was a misimpression. So this is what the order provides. You have 90 days to come into compliance. It's a $250 per diem thereafter. If sadly you're not in compliance, there are 7 separate violations which are per the list of the town of Pembroke Park Code of Ordinances that were read out and that are included in the order. And is that clear to you?
Yes.
Okay. So please remain and get a copy of the order. And please take care of this, because with hurricane season approaching, the most important thing about this case is that, God forbid, this could prove to be very dangerous and also the cause of substantial liability.
Mr. Magistrate, just so you know, the next case that's going to be presented, it's a separate mobile home community, but the violations will be the same, so it's going to be virtually the same situation. So we'll address it at the
Yes,
time.
I understand. What case number is, okay, is that the very next case?
Yes. Code Officer Richwagen, representing.
And give the case number, and for the record, give the case number and give the docket number, please.
No problem. Bear with me for 1 second.
Yeah, we need to do that.
Page 4. Mr. Magistrate, it'll be agenda item 7.8, case 6892. Case 6892, property owner identified by Green Acres, oh no, I'm sorry. Let me restart. Code Officer Richwagen, representing the town of Pembroke Park. This is case number 6892. Property owner identified by Green Acres, Pembroke MHC LLC, site address 3100 West Hollandale Beach Boulevard. The notice of violation and the notice of hearing were issued on 3/30/2022. Both were certified mail on 3/31/2022, and violations were posted to property and to City Hall. Do you want me to read off the entire thing again as per the last case?
I think that for the sake of brevity and expediency, you don't need to, but you do need to summarize the thing again. You don't need to read it verbatim, but you need to summarize it.
Okay. The 2 parts, there's 2 parts that I definitely need to read verbatim. So, Green Acres Mobile Home Park is in violation of Florida Statute 320.8325. A mobile home or park trailer manufactured in accordance with the code standards and labeled hurricane and windstorm resistive shall be anchored to each anchor point provided on the mobile home or park trailer. A mobile home or park trailer which does not meet these standards must be anchored with anchor points spaced as required by the department starting at each end of the mobile home or park trailer. Green Acres MHC is in violation of the Town of Pembroke Park Ordinance, Section 28-285.5. Tie-down requirements for permanent location status vehicles. Any recreational vehicle granted permanent location status shall be tied down in accordance with the standards applicable to mobile homes for such purposes. Ordinance number 00-4-4, 17-4-26-00. The following lots that are in violation, which there is a total of 38, will be Lot 203, 207, 211, 213, 214, 215, 216, 217, 218, 114, 112, 110, 108, 106, 104, 102, 311, 313, 315, 316, 409, 407, 402, 422, 703, 710, 800, 803, 808, 810, 812, 306, 303, 305, 311, 205, 1003, 1007. For Section 28-285.4, permanent location, application, and fee. Any recreational vehicle owner desiring to obtain permanent location status may do so by filing an application or form promulgated by the town and pay an initial application inspection fee as established by resolution of the town commission. Every permanently located recreational vehicle will be inspected annually by the town to verify it is in compliance with the requirements of the town's code of ordinance. The owner of any permanently located recreational vehicle shall pay the town an annual inspection fee as established by resolution of the town commission. Section 28-264, recreational vehicle site dimension. Every recreational vehicle site in an area designated in a mobile home park for occupation by recreational vehicle shall be not less than 1,000 square feet in area and not less than 30 feet in average width. Section 28-267, distance between structures, alpha, no part of any living area within a mobile home or recreational vehicle may be placed, constructed, or maintained within 10 feet of any other living area of an adjacent mobile home or recreational vehicle. Bravo, no. Oh, that's weird. Okay. Bravo section. No combustible accessory structure may be placed, constructed, or maintained within 3 feet of a mobile home, recreational vehicle, or accessory structure located on an adjacent mobile home, lot, or recreational vehicle. Charlie, no combustible accessory structure may be placed, constructed, or maintained within 5 feet of a mobile home, recreational vehicle, or accessory structure located on an adjacent mobile home lot or recreational vehicle. Delta, no part of any living area within a mobile home or recreational vehicle shall be located within 10 feet of any service building or structure used in connection with the operation or maintenance of a mobile home park. Echo, no non-combustible accessory structure shall be located within 3 feet of any service building or structure used in connection with the operation or maintenance of a mobile home park. Foxtrot, no combustible accessory structure shall be located within 5 feet of any service building or structure used in connection with the operation or maintenance of a mobile home park. Section 28-285, attachments of structures. additions, apertures to recreational vehicle prohibited. Alpha, it shall be unlawful to attach any structure, addition, or appurtenance to any recreational vehicle located within town. Bravo, there shall be no addition or attachment to recreational vehicle located on recreational vehicle lot or non-permanent mobile home lots except for a demountable canvas awning. Charlie, the provisions of subsection A shall not apply to any recreational vehicle when said recreational vehicle is parked or located on a full-size mobile home lot in a mobile home park and is tied down in the method required by this code and Florida statutes, as same applies to mobile homes, and is attached to the water distribution system, waterway collection system, and electrical distribution system as required for mobile homes under this code and Florida statutes. Section 2825.1, size restrictions for parking on recreational vehicle lot. Alpha, it shall be unlawful to park, cause to be parked, permit to be parked, locate, cause to be located, or permit to be located a recreational vehicle that exceeds the width of 8 feet or a length of 40 feet on a lot designated as a recreational vehicle. Subsection Bravo, for purposes of the section, the measurements of the width or length of a recreational vehicle shall include any appurtenances attached to any portion of any recreational vehicle except portable awnings, and shall further include any expanded or pull-out portion of such recreational vehicle. Section 28-28.3, minimum space between vehicles. There must be a maintained separation of at least 10 feet between all recreational vehicles parked or located within the town, either on permanent or non-permanent sites. It is my recommendation, based on all this, to give them 90 days to come into compliance with a fine of $250 per day per violation.
Which are 7 violations per the town code sections.
Yes,
cited.
there are 7 violations. And with an admin fee of $100. At this time, this concludes my testimony. This is case 6892.
Ma'am, is there anything you care to say now?
Good morning. My name is Tanae Nichols. The property address, 3100 West Hollandale Beach Boulevard, Pember Park, Florida, 33009. I'm the community manager. We are in agreement. 90 days is sufficient time to complete the violations. Thank you.
You also have,
Thank you for your candor in coming in. So similar to the other order, you're going to have 90 days for compliance. If not, there will be, if you're not in compliance after 3 months, there will be a $250 per diem fee, and there are 7 separate violations. So that would be $250 times 7. I hope it does not come to that, but again, I consider these serious public health and safety issues. I'm sure the town does as well, and you do too. So please come into compliance. I'm taking administrative notice of all the town codes, which are included in the order, and also Florida Statute 320.8325, while is administratively noticed, though that is not enforced by the town. I believe that's enforced by the state agency.
yes, correct.
All right. But it's noted as well. And that's the order. If you remain, you can get a copy of it if you care to.
Thank you.
Cornucopia. Okay. Okay. No, 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 yo no necesito, no, simplemente es que no lo, está bien, yo te creo, yo. Okay.
Okay, next case is on section 9.1.
9.1. Medina Land Holdings.
Yes.
Okay.
Chief Code Enforcement Officer Jocelyn Ramirez for the town of Pembroke Park. Property owner Medina Land Holdings 12 LLC. Tenant MTX Group 1 LLC. Site address 2570 South Park Road, Pembroke Park, Florida. A notice of formal hearing to abate fine was sent out by certified mail on May 3rd, 22, and posted to the property and town hall on May 6th, 2022. This case is here to abate a fine of $8,958.50. The 50 cents again comes from the recording lien fee, which was $58.50.
Excuse me, Jocelyn. Can you
Yeah.
repeat the case
Case
number?
5337. Section 9.1.
Go ahead. I'm sorry. Go ahead with your
So
testimony.
it is the town's motion to abate the per diem fine by 15%. The tenant did pay the admin fee of $100. So it would be the per diem fine abated will be $1,335 plus the recording lien fee is $58.50. So it'll be a total of $1,393.50.
So the town is recommending that the fine be abated to that and paid within 30 days?
30 days is sufficient for you?
The fine is 1,000, you said?
The fine is $8,958.50. The town's motion is to recommend to abate that fine to $1,093.50.
$1,093.50, is that it? I thought you... Just repeat it again, please, Officer Ramirez.
Okay. Is the town's motion to abate the fine to $1,393.50?
I thought I heard 390. Okay, right. Thank you.
I'm agree with that. 30 days. And 30 days is fine with us.
Okay, based on, and for the record, give your name and your address.
My name is Ariel Rodriguez, 2570 South Park Road, MTX Group 1.
Okay. Per the testimony and the evidence, this fine in case number 5337 is abated to $1,393.50. It has to be payable within 30 days. And please note, as a standard in every abatement order, if the amount is not paid in full within 30 days, the original fine amount of $8,958 will again be effective, and I would not abate it further then. Okay, am I clear? All right.
Okay, they have
Thank you.
three more cases.
Okay, so you can wait and give them a copy of all if you want, you know.
Next case is section 9.2.
Right, and what case, if you don't mind, if it won't kill you, please tell us the 9.2, and it's case 5436.
Okay. That's case 5436.
Okay, got it.
Next one is on section 9.5, case 6874. Next one is 9.6, case 6489.
Let's start with 5436, please.
Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, property owner Medina Land Holdings 12 LLC, site address 2570 South Park Road, Pembroke Park, Florida. Tenant is MTX Group 1 LLC. A notice of formal hearing to abate fine was sent out by certified mail on May 3rd, 2022, posted to the property and town hall on May 6th, 2022. The fine requested to be abated is $9,708.50. Is the town's motion to abate this fine by 15%. The per diem fine would be $1,447.50 plus the recording lien fee, which is $58.50, is a total of $1,506.
And 50 cents.
No,
No,
just
okay.
1,506.
Okay. Do you have anything further you wish to add at this time?
No.
Please give your name and your address for the record again, and state if you are in agreement.
Ariel Rodriguez, 2570 South Park Road, MTX Group 1. I'll agree with the one.
And 30 days is sufficient?
No, please.
Based upon the testimony that we've heard, I am abating this fine to the sum of $1,506. And please note that what that means is that if that sum is not paid in full within that period, the full fine of $9,708 will be reinstituted. Next, we can go ahead with case number 6874.
Chief Code Officer Jocelyn Ramirez for the Town of Pember Park, case 6874, property owner Medina Land Holdings 12 LLC, site address 2570 South Park Road, Pember Park, Florida. Tenant MTX Group 1 LLC. A notice of formal hearing to abate fine was sent out by certified mail May 3rd, 22, and posted to the property and town hall on May 6th, 2022. The fine that was requested to abate is $15,100. It is the town's motion to abate this fine by 20% since it's a repeat violation. The amount of the per diem by 15% is $3,400, plus the $100 administration fee is a total of $3,500.
So even considering that this is a repeat violation, the town is recommending an abatement to $3,500.
Yes.
Okay. Your name, your business address, and whether you're in agreement, please.
Ariel Rodriguez, 2570 South Park Road, MTX Group 1. Just want to make a comment on that. We do work for FPNL emergencies, and we would expect an unexpected delivery from them that it was supposed to be to another yard, and they run delivery to our yard. And like I said, it was totally unexpected. It was a lot of material, reels, conduit, and it was a process like 15 days to 21 days to redirect all that materials I got on this side to Miami side. And so when we received that, I spoke to Jocelyn. She gave me like 15 days to remove it. So we finally took like 20-something days to remove it. Finally, we removed it, and we don't have the storage around now. And the only violation there was a repeated violation that it said that it was a silt fence that it always been there for years, because the tenants on the other side, right beside us, we got a couple trees, and they put a new one that was a 16, and we went to a code enforcement. We got the certificate of use, but that silt fence was forever because they don't want to leave on the drainage. So we told them, and we showed the violation. We told them they belong to them. They put it in our chain link fence. We told them they had to remove it. And they called the city, and the city told them that they had to remove it. So that wasn't, I don't justify the fact, but it wasn't our fault.
But it was on your property.
Yeah.
So, I believe in due process and listening to everybody. Now, again, for the fine abatement or mitigation, we're not here to relitigate the case or rehear the case. In the past, a magistrate found this to be a repeat violation, so that's what it is. So, unless you're going to tell me that you object.
Can we reduce it a little bit more, the fine, please?
I think that considering that it's a repeat violation, and because you haven't heard it, my position on these abatements are that and it's up to you, it's your decision. You can either accept what the town recommends, and if you accept it, that's what I will go by, because there's a meeting of the minds. If you don't accept what the town recommends, I will hear the abatement, and I could decide to abate it further, I could decide to abate it less, I could decide not to abate it at all. It's within my discretion. So, if I'm not going to reduce it further, because I think considering that it's a repeat violation, they're reducing it by 80% is sufficient. But if you don't agree, we'll have a hearing on it, and then it's just going to be my decision.
That's fine. I don't want to waste your time. I'll take the 3,000. 3,400. So would you say no?
It's actually 3,500.
Yeah, let me see. Yes, it's 3,500 because the admin fee.
That's fine.
Again, it's your choice, but, okay.
Do you need more time to pay this amount?
In a month, please. 30 days?
30 days is sufficient?
Yeah.
Okay. Or you need more time?
Oh, that's fine.
Okay. Thank you for coming in, and thank you for cooperating.
Yes, one more.
We got one more.
Yes, that's right, you do. You have you had 4, right? You have to.
Chief Code Officer Jocelyn Ramirez, case 6 for the town of Pember Park, case 6489, property owner Medina Land Holdings 12 LLC, tenant MTX Group 1 LLC. Site address 2570 South Park Road, Pember Park, Florida. A notice of formal hearing to abate fine was sent out by certified mail on May 3rd, 22, posted to the property and town hall on May 6, 2022. The fine requested for abatement is $7,500. Again, this was a repeat violation as well. It is town's motion to recommend to abate this fine, the per diem fine, by 20%, which is a total of $1,500. And they already paid the admin fee.
So you're recommending an abatement in this particular case, 6489, to $1,500.
Yes.
Sir, again, for the record, your name, your business address, and Again, it's up to you, but just so you know, if you don't agree, we're going to have a hearing and take testimony from her and from you, and then I'll decide.
That's fine. My name is Ariel Rodriguez, 2570 South Park Road, MTX Group 1. I'm agree with the fine.
Okay? The fine is abated to $1,500. As in the other cases, it's 1 month or 30 days payment. And as in all the other cases, note that if you don't pay in that month, the original fine amount of, in this case, $7,500 will be reinstated. So please pay within that time, and you can put all these cases closed behind you. And now I want to say thank you for coming in and cooperating with the town to resolve 4 cases. Thank you. And you can remain and get a copy of the order of you.
You guys have a good day.
Ashley, $10. $10.
Mr. Magistrate, it will be agenda item 7.3, case 6666.
Thank you. I think we are moving at a steady clip today, so let me take this opportunity to call for a 5-minute recess while I go to the restroom, the construction finish, right?
Can we wait after the case, because after this gentleman, there's no one here? All right.
You have one more.
Oh, there's 2 more. If you want to wait for 2 more, and then we can go on a recess?
Well, when you put it that way, okay.
Okay, thank you. I appreciate it.
Code Officer Richwagen, representing the town of Pembroke Park. This is case number 6666. The property owners identified by Joe Realty Home, LLC, site address 3932 Southwest 52nd Ave, Pembroke Park, Florida, 33023, Unit B4.
666, and again, I'm sorry, but when you, I see it. Case number 6666, right?
Yes, sir.
Okay.
Okay. The notice of violation was issued on 1/28/2022. It was sent out regular mail and was also hand-delivered on 1/28/2022. The notice of formal hearing was issued on 4/12/2022, certified mail on 4/14/2022. The violations were posted to the property and to Town Hall. The violations were there was a bathroom remodel that was done without a permit. My recommendation is 30 days to comply with a fine of $50 for the violations, with an admin fee of $100. And that concludes my testimony for the case, sir.
Is this, hi, and let me just ask a question before, and then I'll hear from you for sure. Are you saying $50 per day if it hasn't, I just want to be very, you're saying $50 per day if it hasn't been corrected?
Yes, yeah, correct. It'll be with a fine of $50 for the violations, because yes, it hasn't been corrected yet. The permits, the violations for the bathroom remodel without a permit.
Right, no, I just, I just wanted to be super clear that they haven't pulled a permit in the interim, but you're asking for it to be found in violation because it was not permitted at the time that it was caught.
No reinspection has been done to this date, so as of right now, no permits have been pulled.
Okay, do you have anything further at this time?
I do not.
Okay, please give your name, your address, and then tell us what you want to say.
Yes, good morning. Good morning. My name is Joseph. So Realty Home LC. So yes, I done the bathroom, but for some reason, it's happening. I'm agree. So I have a contractor that maybe come like tomorrow to submit the application for this issue, but I recommended more time because it's this contractor. Sometimes they take few doses, and some contract work different, slow and faster. So I needed more time and to combine and to make sure fix the situation.
Well, I tend to think that a permit for, for a commode, for a toilet is a fairly straightforward thing, but I'm not a plumber. I don't have a strong opinion about it.
Mr. Magistrate, it was for a, full bathroom remodel.
Oh, it was a full bathroom remodel.
However, I do understand that finding a contractor right now, there is a backlog. So if it would help you,
Yes, I will have a contractor.
will 60 days help you?
Yes, it's fine. 60 days.
60 days? Mr. Magistrate, I'd like to recommend 60 days to comply.
Okay.
Yes, it's fine.
You have my card?
Yes.
Oh, no, wrong card. Where's, oh, someone put that on top of there. Yeah, just stay in contact with me. I know you came in last month, and, yeah.
By the way, I don't mean to be a stickler about this, but, when you're talking here, it's preferable you speak on the record. Go ahead and talk, but just speak
I'm
into
sorry,
the mic. Because
No, like I said, I have the contractor. He's already come here before, so I think maybe today or tomorrow he may bring permit for just the bathroom. Yeah.
Okay.
But I already done the bathroom myself, so.
Okay.
But he's there. He's gonna come just pull the permit. So, yeah, I already have it.
All right, sir.
Yes.
Okay, based on the testimony and the evidence on file, which is all admitted, I do find by clear and convincing evidence shown that there was unpermitted work done in violation of the town code for various bathroom improvements. So I am going to find that there's a violation of the section cited. There's going to be 60 days to comply, and if there hasn't been compliance within 60 days, there will be a $50 fine per day until there is compliance.
Yes.
A $100 fee is charged now because that's charged for any case that comes here. So be aware of that, and that's what the order provides. And if you remain for a moment, you can receive a copy of it to take with you.
So the $100 can pay now or after the 60 days to pay the $100 plus if I don't done the work, it's gonna be included.
You can pay within 30 days.
The $100?
Yes.
The 60 or 30 days?
You can pay the $100 within 30 days.
30 days?
Yes.
Or can I pay right now?
No, it's 60 days for compliance.
Oh,
The $100 you pay within,
60 days.
If you want to pay it now,
$100 you pay within 30 days, okay? 30 days,
Okay.
right? 60 days is compliance. And if you haven't complied, there'll be an additional $50 per day.
Okay, so if I want to pay the $100 now,
yes, you can pay today if you want.
on the front?
Yeah, you'll go to the building department.
Okay.
There you go. When you go to the building department, ask for Jeffrey. Spoke with him last time.
Yes.
Unless you have something else, that's it.
For the AC.
No, sir, you weren't cited for the AC. The only thing you were cited for was for the bathroom remodel.
Okay. All right, thank you.
Thank you.
They have the next case. The case number from the lady.
Next is on section 10.1, case 5641.
Section 10.1.
Hello, my name is Dana Miller, and I'm here on behalf of my mother, Barbara Miller.
Okay, Ms. Miller.
That's fine. We'll hear from you, but we're going to hear from code first, and then we'll hear from you. All right?
Okay.
Okay. Chief Code Enforcement Officer Jocelyn Ramirez for the town of Pembroke Park, case 5641, property owner Barbara Miller, site address 5439 Southwest 41st Street, Pembroke Park, Florida. Notice of formal hearing to extend time was sent out by certified mail on May 5th, 22, and posted to the property and town hall on May 6th, 2022. The violations were for an AC installed without a permit, new sliding glass doors installed at patio area without a permit. The glass doors have been corrected. They pulled a permit under number 1910623-0.
Glass doors were corrected.
Yes, and then a permit for the AC still has to be obtained. I'm recommending, this violation has been open since March 22, 2021. I'm recommending 30 days, if not $100 per diem with a $100 admin fee.
Now, under the code sections that have been cited, I mean, I can check them myself now, but is there one of them that has been cured that should be, that I should interlineate from the order, or you've cited here 5105?
Well, this is an amended final order.
Yes, it is, and
I mean, you can remove it at your discretion, but yes, it has been corrected, but it's the same ordinance. They've been cited under the same ordinance.
so even though it's been corrected, there's still another violation under that
Yes,
ordinance.
exactly.
That's okay. That's why I'm asking, and that applies to all three ordinances.
Right,
Okay, that's why I'm asking, because if not, it was,
right, understood.
Anything else at this time?
Not from me.
Okay, again, please for the record, name, business address, and then tell us what you want to say.
My name is Dana Miller. I'm here on behalf of Barbara Miller, address 5439 Southwest 41st Street, Pembroke Park, Florida, 33023.
What do you
My
want?
mother, she's waiting on the contractor for the paperwork from the contract. She's still waiting on them.
Well, you know, the issue is, you know, for what it's worth, just
Mr. Magistrate, I'm
Yeah.
sorry to cut you off. She hasn't been sworn in.
oh, you weren't here in the morning?
Yes.
Okay, I'm sorry. Then thank you for telling me. Would you raise your right hand and affirm that the testimony you will give is the whole truth and the entire truth, so help you God, I do?
Yes, sir. I do.
Okay. She's sworn in. If you don't mind, just quickly repeat what you said.
My name is Dana Miller. I'm here on behalf of Barbara Miller, address 5439 Southwest 41st Street, Pembroke Park, Florida, 33023.
And your mother is waiting on the contract.
Waiting on the contractor for the paperwork.
So the issue with that, Ms. Miller, and I am, you know, I am sensitive to particularly single-family homeowners who have, residential homeowners who have different circumstances than commercial properties that I consider more sophisticated. But this has been going on for, well, at this point, it's over a year. It's from March of last year. So I happen to think that in light of over 1 year that has gone by, and I'm not you know, doubting your mother's good faith, whatever, but either she or you or someone has to hold, you know, the contractor's feet to the fire or exert increased pressure on them because, you know, again, if you heard what I said earlier, the idea of these cases is compliant, there's two C's, compliance and closure.
Yes, sir.
So, you know, just can't stay open, especially over something that's pretty straightforward like this. So is there anything else you want to say?
No, sir.
Okay, I'm going to enter the amended order. I do think there's a violation for the code sections cited. I think that, we have 30 days for compliance to come into compliance. If not, there's going to be a $100 per day fine. After the 30 days, we ask you, Ms. Miller, to please speak to your mother and stress to her the seriousness of this. Not that the violation is a calamitous situation, but simply in that this has gone on too long, over a year, and she needs to bring it to closure.
Yes, sir.
Okay, am I clear?
Yes, sir.
Okay, if you want to remain a minute, you can get a copy of this order to take with you.
Thank you, sir.
Thank you for coming in. Well, may I call a recess now to go to the restroom briefly, or?
Can we wait 10 more minutes? I'm just kidding. Yes.
I'm going to rule you out of order, okay? Where's the? Where's the? Go back on the record and proceed whenever you like.
Mary, just let us know when we're on the record.
Yeah.
We're on the record?
Yeah.
Okay. Okay, we're going to continue in the order of the agenda.
That's refreshing.
Beginning with case 5397.
Thank you. 5397, you said.
Yes, it's section 6.1.
I want you to, we may have discussed this before, in which case I apologize for being redundant, but while I'm not going to necessarily be reviewing the exhibits or anything like that unless you want me to. In fact, the code
all the
agenda.
exhibits have been entered into the record.
Right. Right, they're in the record, and in fact, my code exhibit, my code section sort of okay, here's the agenda again. So, no, that's another agenda. My agenda seemed to have disappeared from here. I don't know why.
Mary, can you help him find the agenda, please?
It went away. I don't believe I touched this when I went to press it. Oh, that's like a wrong date. Thank you. Is it really?
6.1.
Why do we have all, I don't know. I'll close this, right? Or, yeah, because this, I don't know, but this is the agenda for today, right?
Yes.
So, and this is the case now. Okay, thank you, Mary. Right, what I wanted to say is we still go through everything, but we can do it in an abbreviated, sort of accelerated path, but, okay?
Okay, I'll try to do it expeditiously.
I mean, that's just, if you can. All I'm trying to say is you don't have to use the same.
All right. Chief Code Enforcement Officer Jocelyn Ramirez, case 5397. Forgot to say it, for the town of Pember Park. Property owner 2N Investment, Inc., site address 551 West Hollandale Beach Boulevard, Pember Park, Florida. Notice violation was sent out by regular mail on October 20, 2020. A notice of formal hearing with a copy of the notice violation was sent out by certified mail on March 25th, 22, and posted to the property and town hall on April 5th, 2022. That hearing was postponed on the request of the property owner. Therefore, a notice of formal hearing with a copy of a notice of violation was sent out by certified mail on May 4th, 22, and posted to the property on May 6th, property and town hall on May 6th, 2022. The violations were for prohibited signs, illuminated signs, illuminated signs, and advertisement of signs that covered more than 25% of the window. This item has been corrected.
Oh, it has been corrected.
Yes. Item number 2, exterior maintenance of walls required, pressure wash and paint. This item has been corrected.
That's been corrected as well.
Mm-hmm. Item number 3, exterior maintenance of common areas and parking lot require, pressure wash, painting of parking stubs. This item has been corrected as of yesterday, May 17th.
That's been corrected, okay.
Item number 4, exterior maintenance of wooden fence. This item is in process. It's a process number of 95815. They've removed the damaged wood, but they do need a permit to repair, so they're in the process of doing that.
Yes, the wooden fence looks pretty rickety.
Item number 5, exterior maintenance of damaged chain link fence, i.e. repair or replace with permits. So at this time, they do have a permit in process for it, process number 95815. Item number 6, exterior maintenance of damaged curbs, repair. This has been corrected. Item number 7, overgrown weeds and vines inside of lift station, trim weeds and remove vines from fence. This has been corrected. Item number 8, trash and debris on soil areas and property, remove trash and debris. This item has been corrected. So there's only 2 items that still have not been corrected. My recommendation is to give them 30 days to complete the inspections of that permit that is in process. If not, a $250 per diem with a $100 admin fee.
I note for the record that the respondents have failed to appear, though this has been duly noticed. So based on the evidence, which is all admitted in the record and the unrebutted testimony, there will be 30 days to comply, and if not, there will be a $250 per diem or daily fine. And the order will note or be annotated to say that there remain 2 violations. Right? Is there anything else you want to add?
I just want to state that on the order you will see that it's $250 per ordinance.
Yes.
But they complied with everything, so really and truly it would be just for 1 ordinance.
Okay. That's why I asked you if
How many have been complied or not?
right. You said 2.
Yeah, there's 2 remaining, but it's on the same ordinance.
Right, but I see. Well, would have been helpful if you would have clarified that, because the impression that there were 2 separate violations. But I'll just correct it. Not a federal case. I'll just correct it, and I'm going to note that there is 1 code violation pending. because the reason I ask is because is the 250 individualized or is it dual? So that's why I asked. So
It's individualized, but when we enter it in our system, on our Inc4 system, we only find the ones that have not been complied with.
So look, I'll lay it all out very clearly, hopefully. My idea in making this inquiry today with the cases with the multiple violations is to be very clear, looking forward in time on these orders, if they are not cured, how many different fines are accruing? Because if not, the order might not have total clarity.
Okay.
So that's why I'm asking that question each time.
Okay.
So again, here, you're telling me ultimately it's one violation. It's not going to be 250 times 2.
No, it's not.
So please note the object of my asking that question when you respond.
Okay.
Thank you.
No problem. Chief Code Enforcement Officer Jocelyn Ramirez for the town of Pember Park, property owner. I'm sorry, I didn't even tell you. Section 6.2, case 5506. Case
number 6.2.
Section 6.2, case 5506.
For some reason here, you know what you pulled out here in front of me doesn't have a 6.2. Where is it? I don't see it. 6.2 here. Starts with 7. Thank you. You may proceed.
Case 5506, property owner Law, Hallandale 30 LC. Tenant, Bath and Design. Site address 2940 Southwest 30th Avenue, Pember Park, Florida. Unit 5. A notice of violation was sent out by regular mail on January 8, 2021. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on May 3rd, 2022. Posted to the property and town hall on May 6, 2022. The violations were for Forever Signs contractors, rewire existing sign with new LED lights without a permit, obtain plans permit inspection. At this current time, there hasn't been a permit pulled, but the owner has been in contact with me. Unfortunately, he could not make it to the hearing, but he agreed to the 30 days. And if not, a $250 per diem with a $100 admin fee.
Based on the evidence and record all admitted, based on the unrebutted testimony and the representation about the order, and the compliance by the owner and his agreement, this order will provide that there is a violation as alleged and that there will be 30 days to comply, and if not, there will be a $250 per diem or per day fine. And I believe that those are all the necessary details about this order.
Next case is on section 6.3. Case
5508.
Mhm. Chief Code Officer Jocelyn Ramirez for the town of Pembroke Park, property owner Lakeshore Mobile Home Park LLC, tenant Maria Landaverd and George Sanabria. Site address 108 David Drive, Pember Park, Florida. A notice of violation was sent out by regular mail January 8, 2021. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail May 4th, 2022, and posted to the property and town hall on May 6, 2022. The violations were for installation of an addition without a permit, installation of a roof over without a permit, installation of fence without a permit, installation of AC mini split without a permit, installation of electrical cameras without a permit, and the mobile home owner is utilizing the single family mobile home as a rental unit, which is prohibited. There is prohibited outdoor storage. The mobile home owner has to remove all construction materials. And last, the mobile home exterior requires maintenance. At this current time, the mobile home owner and the property owner has not complied with any of these violations.
Have you been in touch with them?
Nope. They haven't reached out, but the manager, the property manager in the park is aware of the violation. But as far as the actual mobile home owner, no response.
And there's a series of fairly substantial violations here. What is your recommendation, Officer Ramirez?
My recommendation is to give them 60 days, if not $100 per diem fee for each ordinance that they violated, and $100 admin fee.
So here I'm going to note that because it doesn't seem like any of, so 30 days and 100, repeat that again?
60 days.
Sorry. And $100, was it? Or
Yeah, 100. There should be a clause there that says that it would be, or does it say 250?
The clause says, separate fine of $250 per day shall be assessed for each of the above listed violations, which,
Yeah.
come to think of it,
So have to be corrected to 100.
corrected to be 100. And I thought about something now that I don't think this is necessarily that every order has to, if you have gone with, thank you for bringing that up, and it just occurred, if you have gone with a reduced amount, less than the 250, in all the orders, it has to be corrected.
I believe that for the most part, all of them have been 250 until this one.
This one you were recommending a lesser amount for some reason.
Well, because it's, we normally do this for residential.
Okay, I'm going to, unless you want to rerun the page, I'm going to just correct it.
Yeah, we'll, any corrections you made, we'll correct them today so you can have them signed. Because these are already drafted, so all we have to do is change it.
Right, well, here, this correction is going to be on the page I signed.
Right.
So,
Okay, so you can just make the order and then sign it later?
yes, I can do that. I mean, for the moment, I interlineated by hand
Okay,
the 250 to 100.
okay,
But if you want to rerun it, that's
yeah,
fine,
okay,
I think we've done that before where,
yes. But you can wait till we finish.
yes, you can, yeah. Be sure that, There's a lot of orders today, and I will not necessarily.
I can do it now. It's
You want her to do it now? She can do it now.
No. What I meant is the other orders of this nature should be checked to be sure there's not the difference between you recommending one amount and then it's saying.
Okay,
Has
yeah,
to be
we'll
the
check
same.
them.
Right.
We'll check all of them.
No, you don't have to do it right now. You can.
Okay, the next is 6.6.
6. Yes, Lakeville Associates, right? Yes.
Yes. Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, Case 5518, property owner Lake Villa Associates LTD, site address 2300 South Park Road, Pembroke Park, Florida. A notice of violation was sent out by regular mail January 25th, 2021. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail on May 4th, 2022, posted to the property and town hall on May 6th, 2022. The violations were for an installation of 2-inch conduit to feed lift stations without a permit. At this current time, no permit has been pulled. Therefore, I am recommending 30 days, if not a $250 per diem with a $100 admin fee.
Based on the unrebutted testimony, I find a violation here in the case 5518 is charged, and per the testimony, there will be 30 days to comply, and if not, a per diem of $250 per day. It is so ordered.
Next case is 6.
Hang on to your horses, please, because
Sorry.
you have to let me, render the order, okay? Thank you.
Okay. I was trying to do so expeditiously.
Yeah, no, it's good to be expeditious, but, you have to balance that with reasonableness, at least for me. My reasonableness, I guess, sorry. Okay, the next case that we have is, you were saying,
6.7, case 5526.
5526?
Yes.
Yes, a doyon.
Yes.
For doyon.
Chief Code Officer Jocelyn Ramirez for the Town of Pembroke Park, case 5526, property owner Maurice Doyon, site address 4854 Southwest 25th Court, Pembroke Park, Florida. A notice of violation was sent out by regular mail February 4th, 2021. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail May 4th, 2022, posted to the property and town hall on May 6th, 2022. The violations were for installation of new AC, metal roof, canopy, wooden fence, a shower without a permit. Owner has to verify if bathroom renovation and installation were done at home. There's currently no permits for them, but we did get a report of it. Someone called in to report.
Called in to report that?
Yeah. Which this is what's based on that report. These were all the findings. And then electrical alterations done without a permit. At this current time, no permits have been pulled. The property owner was here this morning. He requested time to comply with all the violations. Not sure why he did not stay, but he did speak to the building official this morning, but I didn't stay for the hearing. My recommendation is to give him 90 days to comply with all the violations, if not $100 per diem with a $100 admin fee.
Now, I must ask you this because you said that there was an inquiry or an investigation based on a call or a report.
Yes.
Did that person, I think you know where I'm going, did that person identify themselves?
That was prior to the bill. So, no, they
Per your
didn't.
records, that you're positive that was prior to the bill?
Yes, I'm positive.
Certain?
Yes.
And that's fortunately a red herring. That's a red herring. In other words, that's not an issue.
Mm-hmm.
It would be
Yeah.
after the.
Yeah.
Based on the unrebutted testimony and the evidence, all of which is of record, I find that there is a violation as charged in case number 5526. There will be 90 days to comply, and if not, there will be a per diem or daily fine of $100 per day that will be entered at that time. Next, you have case number 5829,
Yes.
agenda item 6.8. Is that correct?
Yes. Chief Code Officer Jocelyn Ramirez for the Town of Pember Park. Case 5829, property owner, value store it, Pember Park LLC. Site address 2801 John P. Lyons Lane, Pember Park, Florida. Notice of violation was sent out by regular mail May 10, 2021. A notice of formal hearing with a copy of the notice of violation was sent out by certified mail May 5th, 2022, posted to the property and town hall on May 6th, 2022. The violations were for operating U-Haul rental without a certificate of use. Seize all U-Haul rental until business tax receipt certificate of use is approved or obtained. Item number 2, installed U-Haul rental cabinet sign without a permit. Obtain plans, permit inspections. As of May 2021, they did apply for a BTR certificate of use, but it's still in process.
May 2020, I mean, that's a year ago.
Yes, and
How can, I mean, don't mind my asking Chief Code Enforcement Officer, how can a certificate of use be in process for a year?
because they can apply, but if zoning doesn't approve this, which I believe, I don't have all the
Regulation?
the information based on that application they submitted, but I was told from the previous town planner that they were not going to approve that to use that for rental units. So they still, they also don't approve those applications when there's outstanding violations that they have to obtain permits, and they have not obtained permits for that sign that they installed.
So that they, I guess you allow them to apply, but I think it's the norm in many local governments that if you have open violations, you cannot get another permit until you cure those violations.
Correct.
You have that here.
Yeah.
And they have other open violations.
Well, it's this one.
Do you know why the planner said they wouldn't be approved?
No, I believe that, I don't know if she wrote it on paper, but she's no longer here with town, so I can't ask her now, but
No,
I knew
just wondered. Oh, please go ahead.
a new planner is coming, but again, we do have, for now, somebody filling in that role. And it's up to them to follow up with the person. I don't think they have followed up in this matter.
And when you say it's up to them, you mean it's up to Value Store
Yeah.
to follow up, and you don't believe that they have?
because they haven't been in communication with me.
Okay, please, pray tell, continue.
That's all I have. They haven't obtained the permit for the sign, so my
you
recommendation is 30 days, if not a 250 per diem per violation, and $100 admin fee.
And there are how many violations here?
Um, 6 ordinance that they're violating.
On the unrebutted testimony, I'm going to enter an order that there is a violation of the 6 ordinances as charged, and there will be 90 days for compliance. If not, there will be a $100 daily fine for each violation accruing thereafter. And it is so ordered. Is there anything else anybody wants to say about this particular case?
No.
Okay. Thank you.
Next case is 6.11.
Next case is 6.11, which is case number 6886.
Yes.
Please proceed.
Chief Code Officer Jocelyn Ramirez, case 6886. Property owner Kenneth and Cheryl A. Da Silva. Kenneth and Cheryl A. Trusty. Site address 3680 West Hallandale Beach Boulevard, Pember Park, Florida. A notice violation was sent out by regular mail March 25th, 2022. A notice of formal hearing with a copy of the notice violation was sent out by certified mail on May 3rd, 2022, and posted to the property and town hall on May 6th, 2022. There are 12 violations. Item number 1 is wooden fence has erosion and is fallen. Install new wooden or remove wooden fence with permits and inspections. Item number 2, parking vehicles on grass swale areas. Remove all vehicles from grass swale area and restore with new sod. Item number 3, parking lot has cracks, holes, oil stains, and damage. Pave and restripe parking lot with permit and inspections. Item number 4, exterior building and common areas has dirt buildup, pressure wash, repair, and paint exterior. Item number 5, roof exterior has dirt buildup. Wash and chemically treat roof to remove dirt buildup. Item number 6, portable container requires maintenance. Pressure wash and paint portable container storage container to match building color. Item number 7, storing tires outside, storing of appliances, tables, and chairs. Outdoor storage is prohibited. Remove all items and store inside. Item number 8, overgrown hedges. Trim all overgrown hedges. Item number 9, damage irrigation system. Obtain a permit and inspections to repair or remove irrigation system. Item number 10, sales of cars is prohibited and violates the certificate of use business tax receipt. Asian Tires is only allowed to sell tires. Remove all vehicles that are for sale.
And if I may just interject, so your testimony there is that they have been selling vehicles, not just tires.
Correct.
Okay, go ahead.
Item number 11, multiple abandoned vehicles on property, no tags. Remove all abandoned vehicles. Item number 12, dumping trash on swale. Remove all trash and debris from swale area. At this current time, no permits have been obtained, and as of May 6, 2022, no communication and no compliance. But in my initial inspection, which was on March 24, 22, I'm sorry, not March 24, it was February 18, 2022.
Okay.
I did meet with the business owner and mention all these violations as we walked through the property. So after that, there has been no communication.
They respond to anything that you said at that time?
Oh, at that time, they said that they were get it all done in 3 weeks. So,
And,
yes, in February 18.
and zilch. I mean, that did not happen.
Right.
Okay, what is your recommendation here?
To give them 16 days, since there's a lot of things that they need to work on, and if not, a $250 per diem per violation, and $100 admin fee.
How many violations are there here?
Wow.
That I know.
1, 2, 3, 4. $19.
Sorry, you spoke a little softer.
19.
Okay. There are actually 19 open violations.
Yes.
Based on the testimony, I find that there's violations as alleged and as charged in case number 6886. There will be 90 days to reach compliance of all 19 violations. If not, there will be a per diem of $250 per day per violation. It is so ordered. Thank you.
Okay. Next is case 6926.
926.
Chief Code Officer Jocelyn Ramirez for the town of Pember Park, case 6926. Property owner Racetrack Petroleum, Inc., care of Silver Oak Advisors. Site address 3031 West Hallandale Beach Boulevard, Pember Park, Florida. A notice violation and a notice of formal hearing was sent out by certified mail on April 12, 2022, posted to the property and town hall on May 6, 2022. The violations were for permit number 2110813, expired, and it was for replacing leaking, deteriorating STP and dispenser sump.
Dispenser, and what was the expression you said right before this?
Dispenser sump. Sump. That's the terminology from the plans that they submitted.
What is that object? I mean, I just don't know what that is.
That's when you go to the gas station and the dispenser, that's what they had obtained the permit.
Okay. So
it was leaking.
Okay, so the gas, okay, yes, the item that pours the gas into
Yeah.
the vehicle.
Yes. Since the permit is expired and they had done some inspections, but they'd never completed all the inspections from the building department, now the work is considered without permit. So they have to obtain a new permit and complete all inspections.
Have you been in touch with them? Because, I mean, this is, I think, a well-established national.
Well, when I posted on the property on May 6, 2022, I did speak to the property manager there, and she was unaware. She said she's new. So, which is true because I knew the previous manager, but
But I'm sure you.
yeah, but
Go ahead.
but according to Jeffrey from the building department, someone did come in this week and inquire about the permits. So I'm not sure who it was he spoke to, but they haven't communicated with me. So they're communicating with the building department, but they haven't called me to let me know what's going on.
Your standard practice is that the violators reach out to you. Not
Correct.
the
Correct,
way it's
because
always- I'm just asking for,
Yeah.
for the right. Okay.
well, how am I going to know that they're working on it?
Very logical explanation. All right. And
All right.
what is your
Well,
recommendation?
I still have to finish.
Oh, yes, no, please
Then there's
continue. Don't let me, yes, go ahead.
item number 2, permit number 1910284 expired. It was for fuel system repairs, retrofit seals, and 12 pumps, and 3 STP. And so, since the permit is expired, STP sump replacing leaking deteriorated STP and dispenser sump. So that's another permit that expired. They have to obtain a new permit and complete all inspections. Item number 3, permit number 1910671 is expired. It was to remove and replace 12 fuel dispenser. The work was done, so they didn't complete that permit. Now they have to pull a new permit and complete all inspections. So my recommendation is to give them 30 days, since the work is already done. Not a $250 per diem with a $100 admin fee.
Again, this hearing, of course, but I'm only asking this because, again, this is a national franchise or whatever. This has been duly noticed for them to appear here today.
Yes.
Based on the unrebutted testimony and evidence, which is all made part of the record, I find here that there is a violation of 5105, 517, and 52. There is going to be 30 days to comply. If not, there will be a $250 per diem or per day fine for violation. Is there anything else that you want to say here?
No.
Relative to this case? Okay, thank you.
The next 2 cases are on section 8.1
Section 8.1.
and 8.2.
Well, let's take, you can, they're both Anderson.
Mm-hmm.
They're both hearings to confirm fine,
Yep.
but they're somewhat differing violations, so I'm afraid we have to take each one independent, right, separately. Go ahead.
Okay. Chief Code Officer Jocelyn Ramirez for the Town of Pember Park, case 6426. Property owner Gerald Anderson, site address 1708 Southwest 31st Avenue, Pembroke Park, Florida. A notice of formal hearing to confirm fine was sent out by certified mail on May 3rd, 2022, and posted to the property and town hall on May 6th, 2022. The town's motion to confirm a fine for $88,148.50. That includes the recording. Hold on a second. Yeah, that includes the recording lien fee.
So to the best of your knowledge, this amount is accurate and represents a true and correct accrual to date of the fines accumulated.
Yes.
Okay. I am going to enter a supplemental order on the code enforcement lien in case number 6426, based on the unrebutted testimony and evidence of record, imposing a fine of $88,148.50. Gracias. Yes, it's okay. Yeah. Okay.
Good.
Go ahead.
Chief Code Officer Jocelyn Ramirez, case 6905, property owner Gerald Anderson, site address 1708 Southwest 31st Avenue, Pember Park, Florida. A notice of formal hearing to confirm fine was sent by certified mail on May 3rd, 2022, and posted to the property and town hall on May 6th, 2022. It is the town's motions to confirm a fine of $55,600.
And to the best of your knowledge, information, and belief, this amount represents a true accumulation of the fine to date.
Yes.
Based on the unrebutted testimony and evidence of record in this case, I am going to enter a supplemental order imposing a code enforcement lien in case number 6905 in the sum of $55,600. Please note that there is a scrivener's error or correction in the date, which is a date of earlier order, and that date is corrected to April 20th of 2022. And yes, so that order is being rendered now. Yeah.
And that concludes all my cases.
Agenda item 7.5, case 6810.
7.5.
Yes, sir. Code Officer Richwagen, representing the town of Pembroke Park. This is case 6810. Property owner identified by Wilson McNeil and Wilson Angela. Site address 5511 Southwest 32nd Court, Pembroke Park. The notice of violation was issued on 3/9/2022, sent out regular mail on 3/10/2022. Notice of formal hearing was issued on 4/12/2022, certified mail 4/14/2022. The violations were posted to the address and town hall on May 28th, 2022. The violations are as followed. It does say April. Correction, the violations were posted to the property and to Town Hall April 28th, 2022.
Thank you.
I apologize for that.
All right.
The violations are as followed. The entire parking lot for this property is in blight condition and requires repair. There is discoloration on the exterior walls of this property, and the fence in the backyard is in disrepair and in blight condition. My recommendation is 60 days to come into compliance with a fine of $250 per diem with an admin fee of $100. This concludes my testimony for this case, 6810.
Okay, based on the unrebutted testimony of Code Enforcement Officer Richwagen and the evidence of record, I am going to enter an order here finding a violation as charged in the violation notice. There will be 60 days for cure or correction, and if not, there will be a per diem of $250 imposed thereafter. If there's nothing further on this case, that will conclude matters relative to case 6810.
Agenda item 7.7, case 6822.
Thank you.
Code Officer Richwagen representing the town of Pembroke Park. This is case number 6822. Property owners identified by Pembroke Park Lakes, Inc. Site address 3196 West Hollandale Beach Boulevard, Pembroke Park. The notice of violation was issued on 3/15/2022, regular mail on 3/15/2022. The notice of formal hearing was issued on 4/12/2022 and certified mail on 4/14/2022. The violations were posted to the property and to Town Hall on April 28th, 2022. The violations are as followed. The combined electrical meters for lots 142, 144, and 146 are severely damaged and pose a health and safety concern. My recommendation is 30 days to comply with a fine of $250 with an admin fee of $100. This concludes my testimony for this case, and this concludes the testimony for all my cases.
Based on the unrebutted testimony of Officer Richwagen and the evidence and documents of record, I'm going to find a violation in case number 6822 is charged. Electrical items are serious, and that's noted. So, again, to repeat what you said, you're recommending 30 days and $250 per day.
Yes, $250.
I'm going to order that there's 30 days to achieve compliance or correction. If not, there will be a daily or a per diem of $250 per day until there is correction achieved. And that's the order I'm going to render in this case. Now,
Excuse me?
yes.
You have more cases?
No, that concludes all my cases.
Yes, but, we're going to, that's fine, that concludes your cases, but I am going to, not to be, clear about it, but I'm going to remain on the record because there's been a few times that orders are corrected after the hearing, and I've always ended the hearing, but I believe actually on reflection that I am rendering orders at the hearing. So this hearing will stay in session until we're concluded with that. You don't have to remain, but what I mean is that
We are rendering it to the respondent if they're here.
I'm not being clear. Well, let me just say what I mean. So, a few times I've done corrected orders after the hearings.
Yes.
I've stopped the hearing, I've concluded it, but I am still in the act as a magistrate. I'm not talking about the response, I'm talking about what I'm doing here.
Okay.
Of rendering orders. So I'm going to keep the hearing in session until we're done with that.
Okay, that's fine.
You understand?
Mm-hmm.
I haven't done that before, but I think that
That
it's
we should
actually-
do it?
That is the most appropriate thing, yes.
Okay.
All right? This one, we corrected it. Yes. But, all right. The $100, yes, okay. So this one, we want to, yeah. Yeah, we want to, right.
I'm sorry.
Espérate, es que ahora te dije eso. 100, pero es que es lo que se diga para corregir, es que dije mía porque es que no me recuerdo si no lo veo. No tienes que romperlo, simplemente con poner la línea. Tenemos los 30 días, ¿verdad? Pero es que esa parte esa es la parte que tengo que ver. No debemos romper, porque es 60, eso es de esta orden, porque es la única que se ha roto, ¿verdad?
Sí, sí.
Es la única que se ha roto, ¿verdad?
Sí, sí, sí.
Okay. So, we're entering a corrected order in case number 5508. No, está bien, pero cuando, si hacemos eso, la otra nada más, le ponemos la línea, no tenemos que... ¿Vale? ¿No había más nada que tenía que corregir?
Pues las primeras páginas, pero ese no hay necesidad.
Bueno, no, tú lo vas a hacer después.
Sí, sí, sí.
Yo no tengo que firmar eso.
No,
porque no hay más nada en el... I should be speaking in English. What am I? There is nothing else on the second page that I need to correct.
No.
That was the only second page I needed to correct. Correct? Yes, I mean, yes, right.
Correct.
Okay.
Did you check that each order said 250, 250? I know that you wanted to check that.
I wanted to check that. No, I didn't check that.
Okay.
That would be...
Other units.
Yes, I did. Thank you for reminding me of that. I just wanted to be sure that it doesn't say 100 above and then 250 under. Que pegue. ¿Tú hablas español o no?
Sí, sí. Me, yes, but sometimes some words I don't.
Sincronizada, que sean igual. Que cuando ella dice 100 arriba, diga 100 abajo. Si dice 205 arriba, que diga 200. Te está diciendo que nada más vas a revisar los de ellas, lo del otro tipo no importa.
No, yo estoy
Sí, yo sé, yo reconozco.
Yo estoy revisando el de él ahora.
Pero revisa los míos y el otro para el cariño. Pero,
Ella siempre hace lo fácil.
¿Fue eso?
Por ejemplo, aquí no. Este no
Did you, is someone trying to attack the building? Tell me. No, I want the amounts to match. In other words, look, when it says that there, when there's,
This one is incorrect. Value store it, that's not what I didn't recognize, 90 days. I recommended 30 days.
you're sure? Okay. Yes, we're gonna have to. I always try to get everything right, but I'm not perfect, and we move fairly swiftly, so sorry if that is the case.
It was 30 days, 250 per diem, 100,000 feet. It was 90 days was,
Is that the one that we just corrected? The value? No.
No.
It was 5526.
Okay, so on,
Have I to print it again?
yes, on 5829, I'm gonna need a new order, and I'm going to enter a new order that's gonna replace this order. Sorry about that, I apologize. Okay, so 5829, 30 días.
pero te, yes, pero hay uno que está incorrecto.
Another one?
Yeah, because what you have put there was for another case.
Oh, all right, yes, okay. So we'll just correct it now, not a big, I'm usually very, very careful, but sometimes when they fly very quickly, I just,
It probably was at the time that you
so did I like reverse them? Is that what I did?
yeah. Well, you see, this one says 90, 100, so you have that one, right? And then 90, 100 was written on that one too.
Yes.
That
all
one
right.
is 30
And,
and
and,
250.
and 250, all right, so I'm just gonna announce on the record that, I'm entering a new order on this because there was, I had a scrivener's error on the other one. As long as that's what I ordered, and I'm sure it was, right? Of course it was. As long as that's what I ordered, that's fine. Thank you for catching that. Thank you for noting that. Oh, that case is 5829. Do you want to take this with you? Take that with you. Right. Take that with you with just, and I will reissue it. The hearing was quick today, but the number of cases was as much as before, maybe more. It's just there were a lot of defaults today.
Yeah, because there was some that I had like two people who said that, they were okay with the time that I was taking.
They were in concurrence with that.
So, and that they had constraints coming, so, they have.
They weren't able to appear.
So, they agreed, and they couldn't be here.
Right. It just seems to me that based on other hearings that I've had here, that there's always people in an exchange, but that there have been more people here in the past, and today there were as many, if not more cases, but there were a lot of defaults, a lot of non, so we're still on the record, correct? So that's fine. Okay. In case number 5829, which is Town of Pembroke Park versus Value Store at Pembroke Park, I am entering a new order. I'm entering a corrected order, which is just going to be the final order, because actually the ruling or the order in that case was finding of violations, and that there were 30 days for correction. If not, there was a $250 per diem or per day fine after the 30th day if correction or cure had not been achieved within the 30 days. There are 6 separate code section violations on there, right? So I am going to note that again. So I have entered a order which replaces the other order. Simply, this corrects a clerical error. And again, in case number 5829, the same findings, the same evidence, the same conclusions. Simply scrivener's correction by me to be 30 days to comply and $250 per diem thereafter. Thank you for bringing that to my attention. And no rompa esto, nada más lo voy a tirar, no lo rompa.
Okay.
And was there any other, is there any other item, a new matter, new business, correction, clarification, anything at all that comes before the magistrate now?
Nothing else.
Well, I thank you all for your able support, and I want to thank both officers who have been very productive today. I want to thank, there's been less glitches today with the case, so thank you. And I know I haven't seen you here before. I want to thank you. You've been very helpful in timely submitting the things to me. And so again, a pleasure. Thank you. And at this point, which is 12:50, we will conclude